Yes.
May it please your lordship. Well, let's just reflect on one issue that I want to raise. Have your lordships ever heard for the president withholding a bill? Since independence, have your lordships ever heard of the president withholding the bill?
I think there was one occasion during one president's period.
That was for some other reason.
Maybe, but there was.
But
I recollect in my memory.
Yes, I'm aware of that particular, but that was with another intent altogether. But be that as it may, Malas, what's the reason for that? That's just because the parliament is sovereign.
Will of the people.
Will of the people. Parliament is sovereign. Executive cannot. And this president, a president is an elected president. Even then, because there's an element of urgency, the will of the people has to be implemented immediately. And if the president doesn't exercise that leeway, in what circumstances should the governor exercise it? Only an elected, he's not elected. Now, the other constitutional issue. Sorry, Manoj.
Yes.
The other issue is when the bill becomes law, there is a presumption of constitutionality.
Presumption. Always a presumption about it.
Always a presumption of constitutionality.
And the burden is on who challenges it. And
Correct.
It's a very
Correct.
strong burden.
Correct. Now, I explained to your lordships how actually a bill comes into being yesterday when I elaborated the manner in which the law ministries, all these aspects are looked at before a bill is introduced. And the legislation is not concerned with the constitutionality of the bill. That's the domain of your lordships. In fact, these questions are raised in Parliament several times. And some of our members say, but this bill is unconstitutional because
according to you, the legislative competence of the bill cannot be examined by the government.
Exactly. Cannot be. That's why this bogey of timelines and all that is not necessary.
Because the written constitution is lost if you take that position.
No, I'll tell your lordships what that position is. I'm just explaining at the moment, Mullahs, that as far as the legislation is concerned, the parliament, when it passes a bill being a sovereign authority, is not looking at its constitutionality. Several times, Mullahs, we pass a bill. Ultimately, it may be provisions are struck down by this court. Sometimes the legislation itself is struck down. But at the stage of introducing it and passing it, we don't test it. Right? So if we don't test it, Mullahs, what are the three grounds on which you can test constitutionality? Just look at it from constitutional principles. Number one, will the president say, in case it's a bill introduced in parliament, that you are entrenching upon a power of the state in list 2? That's the 254 issue. Will he send it back on that ground? That's one area of testing constitutionality. 2, will he say you are violating a fundamental right of citizen? That's 2. 3, you don't have capacity. These are only 3 grounds, Mullahs, on which a legislation can be challenged. There is no 4th ground. All this will be challenged in a court of law by citizens or by somebody else. So it's in the rarest of rare cases, Mullahs, that a governor will say, no, I cannot decide it for whatever reason. Supposing, Mullahs, in a state university, the chancellor is the governor. Give an example. And Mullahs, a legislation is passed that the chancellor should not be the governor. What possibility will he have to clear this legislation? Supposing in a state there is an issue of private money lenders are charging an interest of 30–40%. And the state wants to pass a legislation, no, this shouldn't be done. It should not be more than 12%. Fundamental question is, what is that leeway? And if you give that power, sorry.
The law related thing, any number of entries in the.
That's right. That's capacity violation of constitutional provision. I'm not disputing that, Mullah. But will the president raise it, or will it allow to be raised in a court of law? Because, Mullah, at that stage, this issue is not to be considered as a matter of constitutional law. The remedies are available under the Constitution. If it's remediless, I can understand. Because it will result in a quagmire, Mullah.
So if we find that the legislation is flung into any central legislation, can it not reserve for the president?
Normally, there's the constitutionality of the presumption of constitutionality. Normally, no. It will apply to a bill also, been passed in the legislature. It's a rare case. It'll be a rare case.
It's a rare case, but like this is nothing. Give an example: if the state legislature passes a bill or legislate a law on the subject of shipping.
In the area of shipping.
Take any
Let's assume, Mullah, first of all, your lordship, these fact situations are never before the court. Mullah, the point is, you are now taking an example that has never happened in the history of the Republic of India, and testing the proposition on the basis of 200 and 201.
Therefore, the question that we are putting is whether in such a case, can the governor not exercise his first option or second option?
It's in the rarest of rare cases, Mullah. I'm saying that has never happened before. We are now assuming something that Mullah, legislations are not passed like this, or bills are not introduced like this. Mullah, supposing there is a price regulation in respect of drugs, Mullah, how these bills are not introduced? You will ask the Ministry of Health, what's the impact of it on the consumer? You will ask the Ministry of Consumer Affairs, what's going to be the impact? You'll ask whether under the drug control order you can do it or not. Should you do it? Should you do it with an essential drug? Should you do it with another drug? Then it goes to the Ministry of Law. These legislations are not passed on the ipsic dixit of ministers, Mullahs. Therefore, I understand what my lord is saying, but it's never happened.
Therefore, even according to you, governor will have to apply his mind at least to find out whether the proposed bill is within the constitutional framework or not.
Well, the problem is, I'm sorry.
Two expressions which I'm again repeating, shall declare presupposes application of mind by the governor. And that application of mind, you can argue that what will be the contours of that application.
Yes.
The other side can also argue what should be.
Correct.
Within that framework, neither he can be treated as a postman, nor he can be a super legislative power to sit over.
Absolutely. Your lordship is right. Your lordship, in fact, asked that question and said that I would address it, Mullahs. Now, let me address it straight away. Mullahs, the bill is sent to him. He doesn't have a formal declaration to be made. He assents to it. His assent is a declaration. Right, Mullahs? There has to be no formal declaration. Two.
Grant of assent is a declaration.
It's a declaration. That's right. So there's no formal declaration. Right. Two, he sends it back. He sends it back. It's a declaration. It's a declaration that he's sending it back, and he's withholding assent. They go hand in hand.
It sends to presidential, again it's a declaration.
That's right. Therefore, and it is withholding. Kindly note the word. Withholding assent is coterminous with his sending it to the legislature and sending it to the president.
What gets excluded is only a pocket veto.
That's correct. Correct. It's completely excluded. Now, the question that what my lord asked, so declaration is clear, Maharaj, it is the act of the governor which itself is a declaration. There is no formal declaration to be made, right? What your lordships are looking at, what are the contours of that? Namely, supposing he starts giving reasons. That this, for this reason, I am sending it back to you. Let's assume, Maharaj. Are those reasons justiciable? Parliament, the state legislature will say, we don't agree. The end of the matter. Even if he has reasons. He'll have to pass it. If it sends it to the president, Malas, and the president sends it back with the same, and still the legislature passes it, it'll have to be passed. So, Malas, the process is what's important. The sovereignty of the sovereignty of the legislature is as significant as the sovereignty of parliament. Supposing all these,
And to them.
that's right. Otherwise, it'll be a violation of separation of powers. So he can do that. So the question is, how soon should he do it? That's ultimately we boil down to that. He can do that, but how soon should he do that? President does it forthwith, never delays it. Should the governor be allowed to delay it? That's the question. Right? Malas, the home cannot function unless there is marital accord, Malas. That equally applies to institutions. You can't create a discord. Marriage will break down. The constitutional machinery will break down. And the court must attempt to ensure there is no area of discord. So there the key words are as soon as possible. It was not later than 6 weeks. They said no, which means forthwith. Immediacy, element of immediacy. Why? The will of the people. Why should people have to wait if the rate of interest charged by money lenders is going to be 50%? Why should fishermen wait if the law is to be regulated as far as fisheries are concerned? Why should that wait? What's the reason? And the governor cannot say, I had no time. Well, there will be extraordinary situations, which is why it is very dangerous to lay down laws without context. This is a very dangerous area. Because then you give examples which are not before you. And then you test those examples on the basis of constitutionality. And those examples may be completely unrelated to reality. So you are given a situation where an argument is being made, give that discretion. Of course, the argument is extreme. He says, if I don't decide a bill for 3 years, it doesn't matter, or 5 years, it doesn't matter, because it is not justiciable. Constitutionalism has to be worked out.
No, the argument is that governor has the power to permanently withhold it.
That's correct. So that's one extreme argument. If your lordships don't agree with that, we still have to find contours within which it must work, Malas. The Constitution must work in a manner that is consistent with the parameters set out in the context of separation of powers and the primacy of the legislature. So, Malas, that's what I wanted to place before you, Malas, before I move on. Malas. Would my lords be, Malas, you'll have to do me a favor, because now it is volume 2.5 and not 2.4, Malas. Because I've incorporated. Yeah.
This is the latest.
Yes, I'm sorry. My mistake. Now, Malas, I'll just cite 2 judgments on. I hope, Malas, when it comes to writing a judgment, the wrong volume is not given to you.
It,
896.
we can discard this.
Yes, please.
Chalo.
Discard that, please. The previous one also. There's the previous one, which I did in the beginning, Malas. That also needs to be discarded. So, Malas, kindly come to Malas, volume 2.5, page 893 and item 4, this judgment, NCT versus Union of India. Well, it's just a couple of paragraphs. Yeah. I mean, I can understand the situation. There is a tsunami, because the state is, everybody is dealing with the tragedy that has happened 2 months past, 3 months, no problem.
Comes. Serious law and order situation.
Correct. Look what's happening in Himachal today. Look what's happening in Jammu Kashmir. Punjab, Punjab is totally inundated. See what's happening in Himachal. You see the timber that's coming down. It's just one wants to cry as to what's happening in our country. Now, in that situation, Malas, there's maybe a delay.
Is appearing for Himachal.
Yeah. So, volume 36, PDF 103, page 13824.
824.
And para 142 and 143. PDF page 103, Malas. It's easier to get that. 5.36, PDF 103. And paragraph 142. It'll take you directly to that paragraph.
Page 13.
13824. Para 142. You have 103. Michael. The room, I'm sorry, Malas.
Yes.
The room for discretion while interpreting constitutional provisions allows freedom to the judges to come up with a formula which is in consonance with the constitutional precepts, while simultaneously resolving the conflict in issue. The following observations in Bomai say, constitutional adjudication is like no other decision-making. There is a moral dimension to every major constitutional case. The language of the text is not necessarily a controlling factor. This is what my Lord Justice Narasimha put to me. It's not a controlling factor. Our constitution works because of its generalities and because of the good sense of the judges when interpreting it. It is that informed freedom of action of the judges that helps to preserve and protect our basic document of governance. It is imperative that judges must remain alive to the idea that the Constitution is never intended to be a rigid and inflexible document, and the concepts contained therein are to evolve over time as per the needs and demands of the situation. Although the rules of statutory interpretation can serve as a guide, yet constitutional courts should not, for the sake of strict compliance to these principles, forget that when the controversy in question arises out of a constitutional provision, their primary responsibility is to work out a solution, which is what I was mentioning to your lordships at the outset. Now come to Maharaj's page. This is PDF 1307.
Whose opinion is this? No. What is quoted of?
Justice Bomai, in Bomai. No. In Bomai.
Doesn't matter. Sorry.
We just mentioned it to your lordship. Sorry. Now let's see the other judgment. Volume 8, page 3414, PDF 307. Meantime, you find out, huh?
Page?
Page 3414, Manoj. PDF 307. Para 90, Malad, that's 30.
114.
Para 90 is at the
414.
bottom of the page. Another principle which this, I'm sorry, my lords have that?
Para 90.
Nice. Another principle which this court has repeatedly laid down for cases in which two constructions may be reasonably possible is that it should adopt one which harmonizes rather than one which produces a conflict between constitutional provisions. Precisely the argument of the other side. You want to create a conflict. No justiciability. I can withhold. That's my power. And I can withhold for as long as I like. Courts, para 91. Courts have been advised to adopt the construction code which will ensure smooth and harmonious working of the Constitution. I'm sorry, Mr. Justice Suryakant. I'm sorry. It was para 90?
Yes, 91.
Yes.
Courts have been
Courts
advised
have been advised to adopt the construction code which will ensure smooth and harmonious working of the Constitution and
Yes, Madam
eschew the other, which will lead to absurdity or give rise to practical inconvenience. Mullah, this is exceptionally important. Or make well-established provisions of existing law nugatory. Now see the consequence, mullahs. I'll now just to contextualize it. Governor says, I'm withholding the bill because I believe that it is unconstitutional for A, B, or C reason. And the state passes it again. And he still withholds it. What's the solution?
But on the second occasion, we can't withhold it.
But if he doesn't, then?
Send it back only, then the legislature will pass it again, no?
Yes. Yes. And
The
he
legislature
still withholds
back.
it.
If he doesn't send it back, then
Still withholds it. Then what happens? By these observations. What happens? If somebody files a petition, governor can't be made a party. Who will defend the governor? Let's not interpret the Constitution to make it unworkable. That's the argument. Under 361, governor cannot file an affidavit. Court cannot issue a mandamus. If he chooses to voluntarily appear, he may appear. You can't interpret constitutional provisions to make the Constitution unworkable. And the language will not matter. The objective should matter. It's a living document. As I said, it owes its genesis to history, but it owes its allegiance to the future. You are the future. You interpret it. Let's not fall into a trap where the governor becomes an impediment in the functioning of the Constitution. Therefore, mullahs, you'll have to say something. Somebody has given a timeline of 3 months. Don't give a timeline, but you still have to say. Ishat had not seen, there is no way that he can withhold if it's passed again. Then you come to deem to. You say the court cannot do this. If you create a problem, you will have no solution. If you seek to resolve a problem, not over a cup of coffee, but constitutionally, you will have a solution. Huh? That's it, Mullah. That's on the interpretation. That's it, Mullah. I don't want to, there's no point in troubling your lordship. Now, let's come back to my oppositions and your lordship, right? Huh? It was Justice M. Ali in S.R. Bomai. Because I was on my propositions where we reached. I'm not going to repeat anything, Malaz, because what has been argued, I'm going to touch. Your Lordships always say, but you still repeat, Malaz, I won't repeat. So far, I have not.
Time will tell.
Paragraph 9 of my submissions at page 896. Under Article 163, the governor must also exercise his functions and act on the aid and advice of the Council of Ministers, with the Chief Minister at the head. Like the President, the governor is, as a rule, a titular head. Article 163, however, creates a narrow exception for the governor. Under 163(1), the governor must act on the aid and advice of the Council of Ministers, except insofar as he is by or under this Constitution required to exercise his functions or any of them in his discretion. Words by and under this Constitution and required in 163(1) are crucial and mean that the power of the governor to act in his discretion must be expressly conferred by the Constitution. Which is why I said yesterday, 200, the concept of discretion is alien to 200. It's a constitutional obligation. The words by or under required, once a constitutional provision provides specifically for the exercise of such discretion, then the governor's determination that a matter falls within his discretionary power is final and cannot be questioned on the ground that he ought or ought not to have acted in his discretion. Except for these provisions, the governor must act on the aid and advice of the Council of Ministers. The position is enunciated in Nabam Rebia. Now, Maharaj, I will not read the passages that Dr. Singhvi read, Maharaj, but I'll read some other passages. Kindly come to paragraph, volume 22, page 8578. PDF 144. Paragraph 87. 87.
Page number?
Page number 8578. PDF page 144. Paragraph 87. The exact argument that was made by the learned solicitor about discretion under 163(1) and 2 was the exact argument made on behalf of the governor by 3 counsel and rejected. Now see Muller's para 87. It was urged that insofar as the present controversy is concerned, a correct understanding of 163(2), this is the argument of the governor in that case, would be of extreme relevance. Under 163(2), according to learned counsel, governor has the authority to act on his own. Same argument. In respect of matters where the governor is mandated to act in his own discretion by or under the Constitution. It was further submitted that when a question arises as to whether such discretion is vested with the governor by or under the Constitution, the decision of the governor on the above question is final and binding. It was submitted that 163(2) postulates 3 situations, where as an exception to the general rule, the governor can act on his own will and discretion. Firstly, when he is required to discharge his functions by the mandate of some provisions of the Constitution itself, in his own discretion. Secondly, when the governor is assigned functions on the basis of enactments made under the Constitution, where he is mandated to discharge his functions by exercising his own discretion. And thirdly, where he is impliedly required to act at his own discretion. Justice Narasimha mentioned that to me yesterday. This is the very argument, Mullahs, that was made in Nabam. Now kindly come to paragraph 89.1. 8579. PDF 145. Well, that was the first time in the history of this court that a dismissed government was put back to a mandamus. Because the governor's action was found to be completely unconstitutional. He chose to summon the House on his own. He chose to fix the agenda of
Kalyan Singh was also put back by court order.
Sorry, brother?
Kalyan Singh.
Yes. Dancing, yeah.
7.
Ah, okay. Now see, Mullahs, 89.1. Mullahs, I'll start with just above placetum B. Herein again. Lordship has that?
89.1 you are reading?
89.1.
Yes.
That's just above placetum B. Herein again it was
Yes, sir.
submitted that the governor would have no role except to the extent contemplated under Article 200. See, Mullahs, the 200 argument was also made. Wherein when a bill is passed by the House, the same has to be approved by the governor. And only when the governor gives his assent, the same assumes the status of a legislative enactment. It was pointed out that 200 contemplates a situation where the governor can return the bill with a message requiring the House to reconsider the same by examining the suggestions made by the governor. This limited responsibility cast on the governor, it was contended, fell within the legislative process. Argument rejected. The governor before whom a bill passed by the Legislative Assembly is placed has also the right to reserve the bill for the consideration of the President. This action of the governor, according to counsel, must be accepted as the further responsibility of the governor within the legislative process. It was submitted that all the functions vested with the governor under 200 are to be discharged by the governor in his independent discretion and not on any guidance or advice. This, according to learned counsel, illustrates the third category of governor's functions, wherein the governor is impliedly required to act in his own discretion, even though he is not expressly so required by any written mandate emerging from Article 200. Rejected. D99. Page 8586. EGF 152. Paragraph 99, Mullahs, if I may.
Paragraph 99.
99. On the issue of discretion, the learned senior counsel placed reliance on 163(2). Based thereon, it was submitted that the governor's discretion for all intents and purposes must be deemed to be final. It was submitted that since 163(2) itself postulates that the decision of the governor in his discretion shall be final, and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, by itself absolves the governor from a challenge to the discretion exercised by him. Precisely the argument. It was submitted that 163(2) was neither a defunct nor a redundant provision, and as such it could neither be overlooked nor ignored. It was contended that the words employed in 163(2) must be given due weightage. If that was to be done, there could be no doubt that the discretion exercised by the governor under 163(2) would have to be considered in a manner as would protect him from the scope of any challenge. These are the contentions. Now I tell you, rejected. 147 and 149, if I remember.
Paragraph 147.
I just 147.1, I think. 1 point, yes. Actually, it starts from starts at page 8617. That's 147.2. 1. The executive functioning of states is provided under Part 6,
Paragraph?
para 147.1. Well, just come, let's skip I need not read the entire paragraph. Kindly read between placetum D and E. Starting, the question that will need determination at our hands. Your Lordship has that? Between D and E. The question that will need determination at our hands is whether the underlying cardinal principle with reference to discretionary power is to be traced to 163.1 or from 163.2.
Where are you reading?
Whereas between D and E, 147.1, starting, the question that will need determination.
Yes.
Lordship has that? At our hands. Is whether the underlying cardinal principle with reference to the discretionary power of the governor is to be traced from 163.1 or 163.2, whilst it was the contention of learned counsel appellants that the same is expressed in clause 1 of 163, the contention on behalf of respondents was that the amplitude of discretionary power of the governor is evinced and manifested in subclause 2 of 163. Undoubtedly, all executive functions of the governor of a state are expressed in the name of the governor under 166. That, however, does not per se add to the functions of the powers of the governor. It is also necessary to appreciate that in the discharge of executive functions, the governor of a state has the power to grant pardons, reprieves, respites, remissions, or punishments, or to suspend, remit, or commute sentences. Governor's power under 161 is undisputedly exercised on the aid and advice of council of ministers. The governor has power to frame rules for convenient transaction of business. The instant responsibility is also discharged on aid and advice. All in all, it is apparent the governor is not assigned any significant role in the executive functioning of the state. We therefore endeavor to examine the duties and responsibilities of the governor, and then, para 148 at 18618, PDF 184. That's the final conclusion. 148. The above position, and Lordship has that? The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions that was assigned to him a dominant position.
Which is that paragraph?
148.
It's 6.8.
8619.
18.
Yeah.
8618.
18, not. Continues over page.
I something over the.
Yeah.
148?
148. I just read that. That really answers everything. The above position leaves no room for any doubt that the governor cannot be seen to have such powers and functions that would assign to him a dominant position over the state executive and the state legislature. The interpretation placed under 163.2 on behalf of the respondents has just that effect because of the following contentions advanced on behalf of respondents. Firstly, whenever a question arises whether he is discharging a particular function, the governor can or cannot act in his own discretion. According to the respondents, the discretion of the governor on the above question is final. Secondly, since the provision postulates that the decision of the governor in his discretion shall be final and the validity of anything done by the governor shall not be called in question on the ground that he ought or ought not to have acted in his discretion, according to the respondent, makes the governor's orders based on his own discretion immune from judicial review. Accepting the above proposition will convert the governor into an all-pervading super-constitutional authority, which Dr. Singhvi read. But it was important to read to go to the alap before we came to the conclusion. This position is not acceptable because an examination of the executive and legislative functions of the governor from the surrounding provisions clearly brings out that the governor has not been assigned any significant role either in the executive or in the legislative functioning of the state. That position adopted in behalf of the Assembly. So this rules out any possibility, and this is a constitution. Well, that's all reflected in my propositions. I'm not going to read them, why waste time with your lordships? Now,
149 refers to
there's also 154. 154.
149 refers
Yes,
to the
149.
constitutional debates and
Correct.
Dr.
Correct.
Ambedkar's
Correct.
Views
That
of-
also. Your Lordship is absolutely accepting the approach. And then, yes, all that will, Ambedkar is quoted and all that. And then it comes to one.
these debates were already.
Yes, therefore, I'm not going to take. Then come to 154. No, page 8622, well, it's PDF 188. But just above 154, well, just 5 lines above the previous paragraph, it is therefore clear, that is placetum, just above placetum B, A and B, the sentence, it is therefore clear. It is therefore clear that even though the governor may be authorized to exercise some functions under different provisions of the Constitution, the same are required to be exercised only on the basis of aid and advice tendered by, under 163, unless the governor has been expressly authorized by or under the constitutional provisions to discharge the function concerned in his own discretion. Whereas this is why I said in the opening, Malaz, 200 is not one such provision. The constitutional obligation. You give him discretion, the Constitution will break down.
Yesterday, for example, 371A1B,
Yes,
where the discretion will be.
exactly. A1, H, 371. And that way the executive field, it's an issue of law and order. Whereas even there, the discretion is qua law and maintaining law and order. It is not with reference to any legislation. Even that discretion, Malaj. Because otherwise he is to be guided by the advice of the council under 371A, Malaj. There is a Hills Council, there are councils, Malaj. So he may differ with that advice. And then if he differs that advice, that discretion is final in respect of law and order. Again, nothing to do with legislation. It can't be, Malaj. It will be contrary to all principles of constitutional law if you start giving the governor that power. We're not going to have to find a solution, Malaj. I come to that later. But first, let's be clear on the constitutional framework. We come to the solution in a while. So then it says, Malaj, it is therefore clear that even though the governor may be authorized to exercise some functions, this is between A and B at page 8622, under the different provisions of the Constitution, the same are required. I've read that. Then 154, we therefore, of the considered view that insofar as the exercise of discretionary powers vested with the governor is concerned, the same is limited to situations wherein a constitutional provision expressly so provides, not by implication, expressly so provides that the governor should act in his own discretion, which is 371A, etc. Additionally, a governor can exercise his functions on his own discretion. Additionally, on own discretion in situations wherein interpretation of the constitutional provision concerned could not be construed otherwise. We therefore hereby reject the contention advanced on behalf of the respondent that the governor has the freedom to determine when and which situation he should take a decision in his own discretion without the aid and advice of the Council of Ministers, Chief Minister and Council of Ministers. We accordingly also turned down the contention that whenever the governor, in the discharge of his functions, takes a decision in his own discretion, the same would be final and binding and beyond judicial review. We are of the view that the finality expressed in 163(2) would apply to functions exercised by the governor in his own discretion as are permissible within the framework of 163(1). And additionally, in situations where the clear intent underlying a constitutional provision so requires, where the exercise of such powers and the aid and advice would run contrary to the constitutional scheme, or would be contradictory in terms. So, Malaj, this clarifies many of the things, Malaj, that have been contended on the other side. Now, Malaj, my submissions. Para 14, yes. Now, Malaj, another provision which I think my learned colleague, Mr. Kaul, referred to, which I think is also important, 167 of the Constitution. There are two provisions that are important for your lordships to consider, 158 and 167. verse 158. The governor shall not be. Let's have that. The governor shall not be a member of either House of Parliament or of a House of the Legislature of the state specified. The reason why he is given a position is because he is to act for the well-being of the state, which is why he is included at the provisions of the Constitution. Because he is acting on the well-being of the state. But he has no legislative role. Just that news. I just wanted to invite your lordship's attention. Now 167. My learned friend Mr. Cole referred to it. Rightly so, according to me. And this is where the hub will lie. Yeah, yes. It shall be the duty of the chief minister of each state to communicate to the governor of the state all decisions of the council of ministers relating to administration of affairs of the state and proposals for legislation. To furnish such information relating to the administration of the affairs of the state and proposals of legislation as the governor may call for. And if the governor so requires, submit for the consideration of the council any matter on which a decision has been taken by a minister, but which has not been considered by the council. So, Maharaj, this is a pre-legislative process exercise, which gives you an indication of the contours of the power if it's to be exercised under 200. Whereas why your lordship sees so often, and your lordship knows, every time the prime minister will go and brief the president. So what has happened? If he goes on a trip, he'll come back and brief him. If there are any proposals, he'll come back and brief him. There are, one nation, one election, he'll go to the president that, this is what we're contemplating. President may, in that informal discussion, this is Q 167, you have another provision, the same provision under the union. He will, have a That's where the cup of tea happens, Maharaj. Not later. Exactly.
Not a cup of tea. Your CM and the PM.
Yes. So this is where all the cobwebs are cleared. Once the cobwebs are cleared and the bill is sent to him, there is no occasion for him to say no. You have to work it out, Maharaj. We have to work out the scheme. So that's where, Maharaj, that conversation takes place. And then when the bill is sent to him, Maharaj, then he cannot say, no, I'm not going to accept it. I'll wait for 1, 2, 3, 4, 5 years.
From both sides. Right. Yes. Except. Right.
I've done that, Maharaj. I've done that. Yes. I remember Maharaj S.V. Gupte was the Attorney General at that time as a young man, maybe 28, 29. And I briefed him in a matter, and we were in outside court number 1. And matter was reaching, and he was smoking Maharaj. And I said to him, Maharaj, matter is reaching. He said, yeah, it's all right. And it reached, almost reached. He said, you go. Bargain. This is the kind of seniors we had. Now you want to take over even what the junior argues.
Therefore, we have stopped mentioning in the.
Now serious
So
compulsory
glad.
orders.
I am so delighted, Maharaj. That's the right thing to do.
Yes. I will.
Why should senior appear in vacations?
Correct.
You should have this thing.
There is. In my court.
Practice procedure, Maharaj, should not appear in vacation. Anyway, I'll get into trouble with that.
Seniors need to get more disciplined now.
I think you have exhausted all your 3 terms.
More or less, more or less. I'm going to, well, as I said, within.
You have exhausted all your 3 terms.
Oh yes, of course, that, of course.
You don't have to bother about that.
No, but Maharaj, one is bothered for the institution. You see, all kinds of things happen, Maharaj. Suddenly you find that your case is reaching somewhere else, so you stop the argument. What? Anyway, that's not right.
Yes.
Kindly come to Maharaj, back my volume 2.5. So, Maharaj, I was at, yes, I've already argued that what is there, Maharaj. I want to read it.
Good, huh?
I've argued, no, not yet. I will finish within the 4 hours given to me, Maharaj. I'll try and, in fact, give more time to others because there's no point repeating things.
Mr. Sybil?
4 hours.
No, this
3 hours.
says 3 hours.
I don't know. I can finish in 3, no issue. I have no problems for us. And let us kindly come now to paragraph. I've done paragraph 15, 16. Then you come, I've also done 17, 18, Naban Rebia. I've read all that. Then page 8, 9, 9, 21. Declare, I've done that. Well, let's not take the time of the court. This, Maharaj. If counsel do not sit in constitution bench matters throughout, they will be heard last. Then make them sit, Maharaj.
And by that analogy, Mr. Gopal Subramanian would have been the first one.
I'm ready. No, but we sat all throughout, Maharaj. We were there throughout. It's only some comfort break occasionally, Maharaj.
Between you going out for some time, but
No, Maharaj.
sometime yes, we have seen.
Only to get the matter adjourned of that sort of pro bono matter.
But you took some 5-minute or 10-minute intervals.
Yes, but he's been throughout
He
here.
has been from morning to evening.
Which is why I've parted with Maharaj.
and glued to the seat right from morning to evening.
Yes. And that's been our practice more or less, Maharaj. Now, sir, I've done declare issue, Maharaj. I've already indicated what that means. Then Maharaj 356. 356 is completely irrelevant to this issue. Because 356, again, as I told your lordships earlier, the only power of the governor under the Constitution is either to accept what the legislature says or recommend. There is no third power of the governor. Under any provision. 356, he recommends. On what basis? On basis of satisfaction. Question of satisfaction is subject to judicial review, but not the judicial review that we contemplate qua administrative action. That's limited. He's taken irrelevant considerations into account. That doesn't apply to 200. 200 doesn't deal with either satisfaction or discretion. So those arguments, those submissions that they made under 356 have no relevance. On 161 pardon, again, it doesn't apply. And on 311.2, just see Malas 300. That's the other area. There are only 3 areas and all recommendation. 311.2.
You read it yesterday?
I didn't. 311.2 I didn't read.
Non पढ़ाई Dr. Singh.
I mentioned it, I didn't read it. 111 I read, not 311. You see 311 and you see, Malas, the proviso to subsection 2, sub-article 2. It says, I'm sorry, Malas, provided that where it is proposed that after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making a representation on the penalty proposed. Provided further that this clause shall not apply to come to B, where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded. So that's the other area. See that where the president of the case is satisfied. So both 356 and 3112 proviso deal with satisfaction.
Subject to satisfaction.
Yes, not relevant as far as 200 is concerned. So all this is recommendatory. Governor has no power. So either you comply with the legislation as proposed to you, or you recommend. Send it back, a recommendation. Send it to the president, a recommendation. No power. If you read into that a power, it will be contrary to this entire constitutional scheme. That's on para 2022. Then 200 I have done. I have also mentioned shall not assent to Malas in 200, second proviso, weigh the powers of the High Court. And my Lord the Chief Justice said that is clear that shall not assent to is different from withholding assent, where the constitution makers want it. So that is at para 24, Malas. I won't read it. That's already heard. Huh? You want me to just read it? All right, 23 and 24 minutes, I will read it on instructions. As such, the governor at page 900. As such, the governor has no discretion under Article 200. The issue of para 23 at page 900.
Page 900.
Page 900, para 23.
And 900.
Yes, at 900. As such, the governor has no discretion under Article 200. The issue of discretion does not arise under Article 200. The provision imposes on the governor a constitutional duty to act in many of the 3 courses of action: assent, return, or reserve based on the nature of the bill presented to him. These are not discretionary choices, but constitutionally mandated routes. Now, how they are to be operated, we'll deal with it. The issue of whether the governor is to send the bill back or reserve it for the consideration of the president on aid and advice of the council of ministers is immaterial, as the governor is not vested with the power to take any final decision on the bill, except assent to it. As seen above, the power to withhold is only recommendatory. If the governor believes amendments are required, he may return the bill for reconsideration, but once the legislature sends it back, he shall not withhold assent therefrom. But the argument is he can still withhold dissent, and further, that he can send it again to the president. Can't be done. There is no choice. But once the sends it back, he shall not withhold assent. There is no choice. Likewise, if a bill derogates from the powers of the High Court, governor shall not assent, but must reserve it for the president's consideration. In neither situation is the governor exercising discretion. He's only following the mandate of 200. Regarding the first proviso, 200 as separate from the substantive part creates an absurdity regarding money bills. That's something that your lordships mentioned. That if he can withhold assent, he can also withhold assent on the money bill. Because that's part of the proviso. So that will be an anomalous situation. So therefore, I'll skip this, Malas. Then Article 200 cannot be read in a manner to create constitutional impasses and litigation between constitutional functionaries. You can't interpret the Constitution in a manner that will create more litigation. But personally, I think that 361 has not been accurately constitutionally interpreted in the context in which it should be read. Otherwise, Balaj, you'll make 200 unworkable completely. The sequitur of giving governor the power to reject a bill will inevitably lead to litigation between the state legislature and the governor, as it has, embroiling the executive and the legislature in protracted conflict, thereby paralyzing governance and defeating the spirit of parliamentary democracy. Conjured facts have no relevance to the issue at hand, Mullah. All these facts that my learned friend mentioned, if he deals with foreign affairs, if the legislature deals, these are all conjured facts. And your lordship should not even look at it. You will decide a matter which is before you, not in the area of any situation which is a chimera, which has no relevance to reality, and you just conjure up something. I mean, legislatures, if you say the governor acts on the presumption that he is the highest executive authority and therefore acts with responsibility, the same assumption must be made in the case of the legislature. That they are acting with responsibility. Then, Malaj, in conclusion, para 29, in conclusion, an interpretation that gives the governor the executive power to withhold assent upends the entire constitutional. The union's argument of separating the substantive part of 200 from the proviso allows the governor to avoid communication, bypassing reasoning, and ignore the primacy of the legislature, all while acting on his own and being immune from judicial review. This creates a one-time, first instance veto, which is free from any kind of accountability. Such an interpretation builds a super-constitutional office wholly incompatible with constitutionalism, responsible government, and democracy. Then, Malaj, comes the timeline issue. So, no more than 6 months, within 3 months, forthwith. Now it's the architecture that you create, which will be the law. And according to me, the following. All this confabulation must happen before the bill is proposed. Any problem that he has, and I'm giving a solution, any problem that he has must be communicated before. And once the bill is sent to him, he must assent. Right. There may be an extraordinary situation that may happen. I will accept that there may be some situation where he still feels that he refers it to the president. Fine. But as soon as possible, forthwith must apply to the governor, must also apply to the president, because the president acts on the aid and advice of the Council of Ministers. So it's the government of India, not the president. So the same, what should I say, necessity of incorporating the concept of immediacy must be engrafted in the action of the president once the bill is sent to him, but he has to send it back. And if it's passed again, he can't say no. That's how the Constitution will work. Otherwise, it won't work.
There is a qualitative difference. Article 201 laid apart
I know.
as against the earlier
Correct.
article,
Correct.
which shall be presented to the
For
president.
consideration. But doesn't matter, Malaj. The government of India.
Saying that because grant assent is what you say.
No, true, but I'm saying that. Malaj, supposing your lordships were to say he need not grant assent, you create the problem. Malaj, ultimately, you will have to decide how it works. Let's assume your lordship's thinking, Malaj. Let's take it forward. That he keeps it with himself. It doesn't respond at all to the will of the sovereign legislature.
They are talking about a solution. Are we saying that the Constitution compels that bills need to be assented?
Yes. Yes, absolutely.
like that.
Yes.
Or else
No, I agree. That's my constitutional premise.
doesn't contemplate a situation
Yes,
where a legislature passes a bill
yes.
and it is not assented to.
By the executive.
President,
President is the executive. Because he acts on the aid and advice of
ultimate
council.
analysis from the legislature, it goes to the governor,
Yes,
it would go back to the legislature,
yes.
then it comes back to the governor. Then first hurdle is that after that he can't refer it to the
Correct.
president. That's what. After he can't refer to the president, that also we need to find the textual requirement for that. And if it is permissible for him to send it, or even in the first instance, then the president considers, that's it. Constitutional text does say that after this consideration,
Correct.
why is it that specifically it is chosen? So therefore, as a court, we need to apply those words.
Yes, yes.
Saying
Yes,
that the president has no option but to accept.
Correct.
You want us to supply this
Yes, yes, absolutely. Because that's the entire constitution.
in the context of the larger principle of
Yes.
parliamentary
Absolutely,
democracy,
absolutely.
federalism and separation.
Absolutely, absolutely. But the consequences would be disastrous. Point is, you are now a Hobson's choice.
So the constitution has not contemplated a situation where under the federalism, the union can not assent to a bill.
Yes.
To stop.
Yes. They will be challenged if ultimately, and you lordships will decide whether it was right or wrong. But he cannot say no. That's the only way the constitution will work. Won't work otherwise. It's the same. The same. But the point is, that's what I said. Exactly the same. So you can't have two different yardsticks. Otherwise, what happens, Malad? The executive exercises a power to overrule the will of the people, whether it's in the state or parliament.
But Mr. Simple, 111 end and 201 end are different. They are not the same.
Shall not withhold a sentence.
No, then it is only sent for his consideration. What does that mean?
But naturally, Malad, I'll tell your lordship. Your lordship is right.
Why it could have been said the same
Malad,
language as 111?
if it shall not withhold assent as far as 111 is concerned, will you read into the constitution that he can withhold assent?
That's what we're trying to find out.
Malad, therefore,
Why differently used?
Malad, because nobody ever, when they framed the constitution, imagined that this would happen. It has not happened till 2022. Since 1950, it has not happened till 2022. This issue has not come up before. Well, ultimately, your lordships will, let's assume now that the fact that it says it for the consideration of the president, there is an element of space within the government of India can say no. Let's accept that. What's the consequence? Litigation. So to that extent, the bill will never see the light of day till it is decided up to this court. Does the Constitution contemplate a situation like that? It's the question your lordships will have to ask. And if it does, fine, Mullah. I only think it will create a lot of litigation for us.
Good for the bar.
Good for the bar. Correct. Very sad for the people of India. Good.
Not good for the country.
With constitutional provisions can't be interpreted in this fashion, according to me. It's a living document. It has energy. It has vivaciousness. It has, deals with situations that we see today cropping up, problems of governance, which we have never seen before. You have to resolve it constitutionally, not over cups of tea. Yeah.
Just last question. Why so? The earlier question, when it goes back
Yes.
from the governor to the assembly, and
Yeah.
the assembly sends it back.
Yes.
The second stage, what is there in the constitutional text to prevent the governor from referring it to the president?
Until, yeah.
First, from the text of the theoretically
Yes, sure.
or a principle,
Please, yes.
the value of the democracy, is
Right.
all right.
Right.
But from the text, is there anything that when it comes back to him after his message, what is there in the text to prevent him from not referring to the president?
The text says he has to accept it.
When it comes back,
It says he shall not withhold assent therefrom. Therefore, he cannot withhold assent.
doesn't say that it have to be.
This is the only option. He has to withhold assent. He cannot withhold assent. That's what the Constitution
The
says.
later part. You're saying for the reason that the governor shall
Reconsider the bill accordingly, and if the bill is passed again, with or without amendment and
You're
presented to
saying
the
that the later portion will give the meaning.
Yes, 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 exactly. Right. Therefore, Maharaj, as far as the governor is concerned, he has to clear it. As far as the government of India is concerned, they need not clear it. Both are executive, Maharaj. No, it's difficult to contemplate that situation constitutionally. So the proposition has to be, he has to clear it. There is an element of immediacy, must be done forthwith. As soon as possible means if it's impossible, that impossibility cannot happen in a constitutionally run regime. There can be no impossibility in dealing with the bill. So must be forthwith, not even 3 months, forthwith. There's an immediacy to the will of a sovereign legislature. And if he doesn't do it, Maharaj, you will have to then, Maharaj, create an architecture for making sure that the will of the people is represented through the legal process. The will of the people can't be subject to executive whims and fancies. Yes, there's a very Now, let us kindly come to Article 254(2). This is the issue of repugnancy. 54(2). My Lord, the Chief Justice has it.
Yes.
Which one?
254(2). I may must read it. Where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list, that's where the repugnancy issue comes up, Malaj, contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in the state. Now the proviso, provided that nothing in this law shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the legislature of the state. So, Parliament has a way out. If they think it's repugnant, they can immediately pass a law. No need to send it back. No need to withhold it. There is a constitutionally provided solution.
Prevention is better than cure, no?
Yes, absolutely. So the point is, Mullahs, there is a constitutionally provided solution in case of repugnancy. This is just a bogey, Mullahs. It's to make sure that these bills of the states are never passed. It's a constitutional anachronism, Mullahs, to interpret the Constitution in this fashion.
The context of your argument, bills which do not employ legislative competence going very well when they are passed, though 254 applies, but nevertheless they need to be assented.
Yes, absolutely.
So it's only in the later part
That's right.
that the court might set aside.
Correct. Absolutely.
But then the bills need to be passed.
That's right. Well, that's the will of the legislature. Well, it's sovereign. You can't have the executive becoming an impediment in the will of the people.
Theoretically.
Yes, not that they are, Manas. We are not. We're answering a question of a reference. Therefore, I'm saying.
A state's bill on citizenship
Yes.
can't be stopped even by the president.
No. You're assuming now, Manas. That's a,
Theoretically.
no, you can't, Manas. I'm sorry, Manas. I'm sorry.
Theoretically.
No. Then I'll take other facts, Manas, theoretically, which will destroy the argument, Manas. But that's, what's the
Your argument that it could be tested only in a court.
No, Malas, your lordship is assuming that there will be a state legislature in this country. Malas,
But it will not be in a situation.
Malas,
I gave you an extreme example.
but that extreme example should not lay down. As somebody said, bad examples like bad the law, Malas. My lord differed with that. And I was,
Hard cases make good law.
that's right.
Yes.
So, Malas, yeah, these are assumptions made that they will pass a law in respect of foreign affairs, and then an argument is made. If we are not going to deal with facts, then we cannot deal with these assumptions. When that issue comes up before your lordships, you will deal with it. But you can't deal with it in a reference without the fact. Because you are now assuming something. They say, don't refer to what West Bengal did, don't refer to what Tamil Nadu did, don't refer to these facts, but refer to my facts. Both ways. So I accept what my lord is saying, Malas, but that's not something that's going to happen.
Ask a question, it's know the interpretative.
I understand.
methods.
The interpretation is very simple. I mean, that's a constitutional thread that runs through the Constitution.
Those of us are well trained. So don't get upset.
Executive barred from interfering in the process of legislation. Constitutional bar. Therefore, this whole question about I'll have to file a writ petition and the governor will, it's all irrelevant. None of this should happen. It be done forthwith. Only question will, even after it is sent by the legislature back, he still withholds it. Know what happens? That's the only area where your lordship will actually have to lay down. Now, whether it's deemed to be passed, or what procedure you will create for the insurance, to ensure that the will of the people is carried forward, is you'll have to create that. I can't provide a solution for that. But remember one thing. Do not allow, as a matter of constitutional law, the executive to interfere in the will of the people. That's all. Well, theoretically, has any parliamentary legislation passed a law violating list 2? No. If they do pass a law, what happens?
It's simple. Examining, let us say, academically, there is no instance. The power of parliament under proviso 2 is not a substitute or is not to render the power of the governor to reserve a bill for the presidential assent as redundant.
You're right.
Those two powers are independent and they will coexist.
Exactly. No, I agree. I agree entirely.
There can be an example where the governor may assent to a bill that will become act. But in due course of passage of time, the parliament may experience that one of the provision of that act is repugnant. And therefore, the
Proviso comes.
amendment back to that
Absolutely right. I entirely agree.
they find
Correct.
that it may create.
Absolutely right. But that can happen at any stage. It can happen earlier also. It can happen it's straight away when the bill is sent and they feel that there's a problem and there's a problem of repugnancy, they can pass a law. So it can happen, but there's a solution provided in the Constitution. But that solution is not that I sit on it and not give assent to it. And that's true of everything into, but Maharaj, the other thing that I wish to say, and I say it a little later, I'll try and finish by.
In other words, the proviso under 2
Yes,
is a second filter.
yes,
That if a mistake is committed there,
yes.
Parliament still enjoy that power.
That's my submission, Maharaj. Now, let's kindly come to 34. So, Maharaj, basically 34 and 35, that the decisions must be taken forthwith. There's no question of 3 months, 6 months, 6 weeks, forthwith. Unless it's impossible, because that's as soon as possible. Right, Maharaj? And 36 says, the words as soon as possible in 200 refer to the hiatus between the presentation of the bill and its return for reconsideration by the legislature. Whereas what happens is there are a couple of stages here. Number one, you send the bill, he doesn't deal with it. So what happens to as soon as possible then? He just doesn't deal with it. And that's not hypothetical. So as soon as possible has no meaning. So he has to deal with it, and he has to deal with it forthwith. And he has to send it back. And the processes should be completed in under 167. Then there can be no impediment. If they are not completed, even then, he must forthwith send it back, whatever his comments are. Or forthwith send it to the president. He can't delay that also. Supposing he says, I'm sending it to the president, but I'll take 2 years to do that. You can't do that. So that your lordships will have to clarify. The matter of constitutional law. And if it reaches the president, the government of India must forthwith send it back with whatever comments they have. And we need not have to litigate on that. Once the declaration of the law is there, there'll be no litigation. Then come to Maharaj 36. The words as soon as possible in 200 refer to the hiatus between the presentation of the bill and its return for reconsideration by the legislature. This phrase barely recognizes that some additional time may be needed when the governor chooses to withhold assent and send the bill back, and requires that even this be done with the greatest expediency. Thus, absence of words as soon as possible in the substantive part does not permit endless deliberation. It indicates an inbuilt constitutional mandate that the decision to assent, withhold, or reserve must be taken even faster as soon as possible, that is, forthwith. Constituent Assembly originally provided. Well, your lordship has that 6 weeks and all. No repetition. Then, well, let's come to the another argument made, which is judicially manageable standard. He said, look, there are no judicially manageable standards. If he withholds the bill, how are you going to decide whether he's right or wrong? There are no judicially manageable standards. But the concept of judicially manageable standards is not a matter of constitutional law at all. Well, that's directive principles of state policy. What your lordship says, these are the judicially manageable standards. How do we implement that? That's for the state to decide. Comes to equality, you say, we'll decide. All of part 4, duties of citizens towards the state, not judicially manageable. Because that's in the area of either policy or in the area that if there is a rule of evidence that in the absence of facts, you cannot do anything. I must pay allegiance to the Union of India. The duty, not judicially manageable. That's nothing to do with 200. So para 39, first, once it is accepted that the governor does not enjoy an untrammeled power to withhold assent, the natural sequitur is that his decision must be taken within a reasonable time frame to reject the notion of an absolute veto while simultaneously holding that the courts cannot prescribe and enforce a timeline is to create a constitutional absurdity. It would amount to allowing the governor to sit on a bill indefinitely, thereby achieving through delay the very outcome of which the Constitution prohibits. If you say, okay, he cannot withhold the bill, but you say that no, he can sit. When I send the bill to him, he can sit, Malas. That is also amounts to withholding the bill. If you reject that argument, you'll have to reject this. You can't have through an interpretive process the same outcome of withholding a bill because there's no timeline to be adhered to. So the timelines required are integrally linked to the process of immediacy and cannot be allowed to result in withholding the bill. Becomes clear when one considers the 3 stages to the time frame. When a bill is presented, the requirement as soon as possible demands that assent, withholding, or reservation be declared forthwith. If the governor fails to act, the court cannot prescribe a time frame. It is equivalent to conferring an indefinite veto. Don't have a time frame, there will be a veto. 2, when a bill is returned to the legislature and comes back, Article 200 says governor shall not withhold assent. If no timeline can be enforced, the bill once again becomes again a veto. So the very malaise that you tried to prevent exists in not having a timeline. But it will amount to withhold. C, where a bill is reserved for the president, and that too must be done forthwith. If the governor chooses not to send it and the courts are powerless to intervene, it is nothing but a disguised power to withhold. You come back to the same question. All right, don't give me the power to withhold, but don't give a timeline which will result in withholding. Cannot be a principle of constitution. So there are judicially manageable standards which are part of Article 200, are integrated into 200, and immediacy, forthwith, soon as possible, without delay, part of the constitutional structure. So there's no question of judicially manageable standards. Then come to 44 straight away. Thus, time limits prescribed by constitutional courts under the circumstances above are not to be equated with judicially enacted constitutional amendments. He said, well, the argument was that, look, if you give a timeline, you're amending the article. Not. You're ensuring that the article functions, that the constitutional machinery functions, not that you're amending it. As recognized in, let's leave that out. Then 545 minutes. There is no automatic or self-executing consequence to crossing the time limit. It simply triggers judicial scrutiny. The timeline set by this court does not mean that the governor is mechanically bound to act within 1, 2, or 3 months in all cases. Rather, it means beyond the prescribed period. If an objection is raised, the governor or the executive as whole must satisfy the court that the delay was justified and free from abuse. Quite frankly, Maharaj, this is not relevant because that's not my argument. This is what the Tamil Nadu judgment said. Now, Maharaj, kindly see para 46. That's very important, Maharaj. The timelines prescribed by this honorable court are also based on the following. Maharaj, Tamil Nadu provided some timelines, but based on what? Office Memorandum of the Ministry of Home Affairs, Government of India, dated February 4, 2016, issued to all ministries and departments of the government, acknowledging the undue delay in clearing reserved bills despite an earlier guideline of 22nd September 92. The memorandum thus admits that decisions on reserved bills must be taken expeditiously. That's the memorandum on which was Tamil Nadu relied. But that's the constitutional purpose. The Sarkaria Commission, Punchi Commission, both recommended timelines. I'm not on timelines at all, Malas. My argument is different. You give them timelines, they breach the timelines, you destroy the constitutional working of the Constitution. Then, Malas, judicial review. Want me to read? Not necessary. I've already made the argument. Yes, yes. Then you come to.
131.
No, kindly come to para 52, Maharaj. Para 52. Because my learned friend talked about justiciability. He said, it is not justiciable. The question of judicial review doesn't arise. Well, let's kindly see para 52. An absence of judicial review may be presumed in areas such as fundamental duties under Part 4A of the Constitution and broad economic policy. These are rules of evidence. You don't have the facts. Further, matters relating to relationships of confidence, which are protected by the concept of privileged communications, are not matters for judicial review. This is based on the principle that the rule of evidence does not allow them to be matters for judicial determination. Because you just don't have the facts. Similarly, acts of the executive in which law and order is required to be maintained in respect of in situ situations are again not matters for judicial review. 371A, 371H. This is reflected in the discretionary actions of the governor under 371A, which are pure executive actions and cannot be regulated through judicial determination. However, the principle does not apply to specified constitutional obligations of either the executive or the legislature. Well, as another argument was made, see, you have timelines. Wherever the Constitution wants timelines to be provided, they are provided, but all of them are legislative. There will be a 5-year term of the Assembly. There's a 5-year term of Parliament. That's the bedrock of democracy, timelines in respect of legislation. Elections will be held in such and such time, within 6 months of the Assembly being dissolved. It is not in the functioning of the executive. If there exists a provision, the contours of which are clearly established, within which the executive or the legislature is to function, and which impacts Part 3 of the Constitution, or is reflected in constitutional provisions delineating the powers and responsibilities of the constitutional authorities, then such action is subject to judicial review and is justiciable. Article 200 is one such provision. It is not a provision that requires the governor to be satisfied, as in the case of 356. Therefore, the question of justiciability does not even arise. Thus, Article 200 is within the powers of the court's judicial review. Then, my lords, The judicial review is invited. The moment he kindly come straight away to 59 now. Oh, sorry, what? 9, yes. Now, it's 59 is Rameshwar Prasad, right? This is page 908. Malas, if I may, Malas, just read 361 with you again, Malas, the Lordship permits me. Just so that we clarify the contours of 361.
Yes, sir.
The president or the governor or Raj Pramukh of a state shall not be answerable to any court for the exercise and performance of powers and duties of his office, or for any act done or purporting to be done in the exercise and performance of those powers and duties, provided that the conduct of the president may be brought under review by any court, tribunal, or body appointed or designated by either House of Parliament for the investigation of a charge under 61, provided further that nothing in this clause shall be construed as restricting the right of any person to bring appropriate proceeding against the government of India or the government of a state. Just pause here. If you allow the governor the personal power to take a decision, neither the government of India nor the government of the state is involved. How will 361 apply when it's the decision of the governor that I will not give you assent, or that I'm keeping the bill pending? Government of India can't defend him. Government of a state is at odds with him. How will a writ petition lie? You can't interpret 361 in this fashion. If you give that power to the governor, if you give that power, my argument is that you should not do so. But if you do give that power, then he's answerable. Then 361 will not stand in the way. Can't have it both ways. You take recourse to 361 saying he's not answerable, and you give him the power under 200, and you say governor will not file an affidavit, and court can't issue a process, then you're making the Constitution unworkable. Because that's the only act in which he is not accountable. There is no act in the Constitution which makes the executive not accountable. Court. This is a provision where you will give that. You can't have an absence of accountability as a constitutional provision. Therefore, mothers, that's why I've been saying time and again, the governor has no such power. The situation should not arise, should not be allowed to arise, is not constitutionally permissible. He has to give assent. The president has to give assent. And litigation will take its course, whether it is repugnant, not repugnant, whether it violated a constitutional right of citizens, did not violate, whether whether the legislature had the capacity to enact the law. These are situations that would arise in the course of litigation, and you will decide. But he has no power not to assent. Only question your lordships have to do, if despite that he does, then what's the remedy? That's the only area where you have to create an architecture for a remedy. Either deemed assent or some other thing. Just wanted to flag that issue. for your lordship's consideration. Then, Mullahs, really, Rameshwar doesn't answer that question. I'm just, Mullahs, since your lordship said, doesn't answer that question. Because again, Mullahs, the problem that with us lawyers is the following, Mullahs, and I must concede that we are guilty of that. We take out a sentence from one judgment and we say that it's the exposition of the law, realizing that every judgment is contextual, arises from the facts of the case, has no bearing on another issue, which has where the facts are not before you. And there are very famous words. Not part of the, it's not part, but we've handed over a hard copy. Just have a look at that since I just finished this aspect. This is an Oriental Insurance Company versus Rajkumari. Para 11. Just give the judgment, please. I'm sorry, Malas, but we'll put it in the... Five, okay. Yes, yes. Yeah. It's here. This judgment at page 1146, Malas, on the left-hand side top, at the bottom, paragraph 11. 1146, paragraph 11. At the bottom, if I may read. Reliance on the decision without looking into the factual background of the case before it is clearly impermissible. A decision is a precedent on its own facts. Each case represents its own features. It is not everything said by a judge while giving a judgment that constitutes a precedent. The only thing in a judge's decision binding a party is the principle upon which the case is decided. And for this reason, it is important to analyze a decision and isolate it from the ratio descender. According to well-settled theory of...
Said in Dhanvantari Devi.
Yes, exactly. That's why, Malas, in the 2G case, when auction was prescribed for telecom, in the telecom sector for spectrum, the question arose, does it apply in every other case? And your lordship said, well, as far as spectrum is concerned, it's fine, but it can't apply to other cases because the fact situation is different. So, Maharaj, how can a principle of law, say in Nambudiri, for example, it was said that the House stood dissolved, the Assembly stood dissolved, and the matter was pending before the President. And since there was no timeline, even if the Assembly is dissolved, the bill can be passed. Right, Maharaj? That's what Nambudiri is. The argument is the court has said no timelines. Therefore, no timelines in 200. The relevance of that to what we're discussing today. So you can't take a judgment like that and set up a constitutional principle that no timelines will apply in 200, when that was not the issue before the court. The question is whether the bill survives or not, because it's awaiting the consent of the President, and the court said it survives. That's the mistake we commit. So it says, findings of material facts direct an inferential finding of facts is the inference which the judge draws from the direct or perceptible facts, statements of principles of law applicable to legal problems disclosed by the facts, judgment based on combined effect of the above. A decision is an authority for what it actually decides. What is of essence is that in a decision is its ratio, and not every observation found therein, nor would logically flow from the various observations made in the judgment. The enunciation of the reason or principle on which a question before a court has been decided is alone a binding precedent. Case is a precedent and binding for what it explicitly decides and no more. This goes on, Maharaj. Court should not place reliance on decisions without discussing as to how the factual situation fits in. That's para 12. with the fact situation of the decision on which reliance is placed. Observations of courts are neither to be read as Euclid.
That's what Dharmantari there is says.
That's right.
Slight distinction in fact.
That's right. So well, let's not.
With application of the same law.
Yes.
Will lead to divergent results.
Correct. So you can't apply 356 to 200. You can't apply Nambudiri to this. You can't apply Veluri to this. Then, this is at 909, para 60. I've done my argument on 361 already, so I will not read it, It only talks of 361. Then comes, the 131 and 132. Before that, kindly come to an issue that I wish to raise, not on maintainability, but kindly have a look at, where's that table? No, the table where, previous table. Yes. Annexure A, page 911, Now, I have set out here all references made in the past, all references. And no reference in the past similar to this one, because in each reference, there is a specific question asked. In each reference. I'm not on maintainability. But I would request your lordships to be careful when deciding a matter of this nature, dealing with a hypothetical situation in the absence of facts. What has been directly argued is that the governor has immunity, that he can withhold assent, that your lordships must answer. But there are several peripheral issues which are not before you. It's not on maintainability, it's the discretion of the court whether to answer all the questions or not to answer all the questions. Now kindly look at this chart at page 911. Delhi Laws Act 1912, in re 1951, SCC 568. What is the question? Was Section 7 of the Delhi Laws Act or any of the provisions thereof, and in what particular or particulars or the extent ultra vires alleged? Would direct question, Mother, that your lordships had to answer on the light of the law that was operative. Then Kerala Education Bill, 1958 reference, does subclause 5 of 3 of Kerala Education Bill read with clause 36 violates, offends Article 14? Direct question. Come to Berubari Union, famous case. Direct question. Kindly come to Sea Customs Act, 1963 Supreme Court. Direct, do the provisions of 289 of the Constitution preclude the Union? Direct question. Privilege immunities of state legislatures? Direct question. Presidential reference, 1974? Direct questions. Special bill, special courts bill? Direct question, whether the bill or provisions thereof, if enacted, would be constitutionally valid. In fact, Justice Chandrachud in this judgment, Senior Chandrachud said that, look, even this is very vague. You should have told us which are the provisions that should be held to be invalid. The court is not here to tell you whether the court is not performing that exercise. You want to ask me a question, you ask me a question. I'll right side that. Kaveri water dispute, direct question. Ismail Faruqi, direct question. Special reference, 1998, direct question. Jammu Kashmir grant of permit of resettlement, direct question. Special reference 201, direct questions. Special reference 202, direct questions. Natural resources allocation, direct question. Tell me which reference has ever been made like this? You're asked to answer on all kinds of assumptions. All kinds of scenarios are put before you. That's the duty of the court. Do not conjure up scenarios and then answer a question. What will happen in 131? What will happen in 32? When it happens, then you'll answer that. You'll answer that through your judicial process. But you're not going to take examples like that and answer questions. It's the job of the government or the president in the reference to tell you, this is what we are troubled by. Does arise or likely to arise? How does Maharaj 131 likely to arise? Or 32, whether it lies or not likely to arise? How is it relevant? So, Maharaj, now let's look at that. First of all, Maharaj, what Justice Chandrachud said in Rebbe. Which is that? Volume 9, page 3685, PDF 184, para 30. This is where they said, you just tell us whether the bill is unconstitutional or not. What does Justice Chandrachud say?
Page number?
Page 3685, PDF 184, paragraph 30, volume 9. I'll just have it, Maharaj. My Lord Chandrachud has it. May I read it, Maharaj? May I read it, Maharaj? We hope that in future, whenever a reference is made to this court under 143 of the Constitution, care will be taken to frame specific questions for the opinion of the court. Fortunately, it has been possible in the instant reference to consider specific questions as being comprehended within the terms of the reference. But the risk that a vague and general reference may be returned unanswered is real and ought to engage the attention of those whose duty it is to frame the reference. Were the bill not as short as it is, it would have been very difficult. It would have been difficult to infuse into the reference the comprehension of the 2 points mentioned by us above and which we propose to decide. A long bill would have presented to us a rambling task in the absence of reference on specific points, rendering it impossible to formulate succinctly the nature of the constitutional challenge to the provisions of the bill. And somewhere else it is said that it can't be hypothetical. Yes. Then Miller's para 26 is very important. Para 26 at page 3684. The second objection, this is an objection to maintainability. I'm not on maintainability, Miller. We're beyond that. The second objection to maintainability of the reference is that it is vague, general, and of an omnibus nature. The question referred to by the President in this court is the following: whether the bill or any of the provisions thereof, as if enacted, would be constitutionally valid. It is true that the reference does not specify with particularity the ground or grounds on which the bill or any provisions may be open to attack under the Constitution. It does not mention whether any doubt is entertained regarding the legislative competence of the Parliament to enact the bill, or whether it is apprehended that the bill, if enacted, would violate any of the fundamental rights, and if so, which particular fundamental right or rights. A reference in such broad and general terms is difficult to answer because it gives no indication of the specific point or points on which the opinion of the court is sought. It is not proper or desirable that this court should be called upon to embark upon a roving inquiry into the constitutionality of a bill or an act. Such a course virtually necessitates the adoption of a process of elimination with regard to all reasonably conceivable challenges under the Constitution. It is not expected of us, while answering a reference under 143, to sit up and discover, article by article, which provision of the Constitution is most likely to be invoked for assailing the validity of the bill if it becomes law. The court should not be driven to imagine a challenge and save it or slay it on hypothetical considerations. Save it or slay it on hypothetical considerations. As observed in Hamilton, speculative opinions on hypothetical questions are worthless, and it is contrary to principle, inconvenient, and inexpedient that opinion should be given upon all such questions at all. It applies directly to this case.
Read 27.
We are at one stage of the arguments so much exercised over the undefined breadth of the reference that we were considering seriously whether the circumstances it was not advisable to return the reference unanswered. But the written briefs filed by the parties and the oral arguments advanced before us have, by their fullness and ability, helped to narrow down the legal controversy surrounding the bill and to crystallize the issues which arise for our consideration.
In
We
2G,
close to limit.
in 2G, DK Jain explains
Yes.
what is to be done by a reference court.
Yeah.
Then there is uncertainty about the.
Yes. Now, if you look at the questions here, you are conjuring up issues, Manoj, which may never arise. Now, just look at the questions. My iPad, yes. I'm not going to delve much on it, Manoj, just so that you have to, in ultimately deciding this matter, have to be careful where you want to give an opinion and where you don't want to give it. Volume 3, Manoj, page 7.
Volume 3, page.
Manoj, page 7, Manoj.
PDF page 7.
Volume 3, page 7, Manoj. Index and documents, volume 3, Manoj. It's part of the
Coming to volume 3.
volume 3, Manoj. Index and documents, volume 3, Manoj, page 7. It's now, as far as 1, 2, and 3 are concerned, they arise. They are specific.
Yes.
I have no problems with that. 1, 2, and 3. Though constitutionally, 1, 2, and 3, Manoj, whether constitutional options before a governor when bill is presented to him under 200. I mean, it's not in the context of any facts, Manoj, but let's assume, Manoj, that your lordships can consider reading 200 and answer that. Then is the governor bound by the aid and advice standard? Let's assume that. Is the exercise of constitutional discretion under 200 justiciable? Then Article 361 is an absolute bar. How does that arise? What's the relevance of that here? No such thing has happened. Why should you answer it? The absence of constitutionally prescribed time limit. Why do you assume that? You're going to interpret 200, interpret 200. You can't assume that there is no prescribed time limit. How do you assume that question? Assume that it requires to be decided. You interpret 200 in the matter that constitutionally, and then that will be the end of the matter. Why do you assume that there are no constitutionally prescribed limits? This is an assumption made, Manoj. Can't be a question on an assumption in constitutional law. The exercise of constitutional discretion of the president. It's all part of 200. That's not arisen in any situation, Maharaj. Kindly see. This question of 201 has not arisen in any situation. You're asked to answer the. In a fact situation, if it arises, you will answer it. At the moment, it is obvious, Maharaj, and I can say it up front. It's obvious there's a judgment of this court and somebody wants to say that, no, that's not good. In the light of constitutional scheme governing the powers of the president, is the president required to seek advice of the Supreme Court by way of a reference? You're directly dealing with the judgment. If that arises, you decide it. But you're directly dealing with the judgment, which is prohibited, as you know. It will be challenged, Mullahs. I'm sure it will be challenged. You may set it aside. No problem. But this is no way, Mullahs, to get an answer. Are the decisions of the governor and the president at 201, 200, 201 justiciable at a stage anterior to the law? How is that? Is that arisen anywhere, Mullahs? Anterior to the law? Has it been said by any judge, Mullahs? Can the exercise of constitutional power and the orders by president be substituted in any manner under 142? Not arisen. It has arisen in a particular context and the particular facts of a case which was rendered, on which a judgment has been rendered. You can't tangentially, Mullahs, attack the judgment in this manner. Yes, you can say that judgment is wrong and it will happen. It will happen one of these days in some other case. Go for review, you go for curative, or you in another case, attack it. And many a time your lordships have changed your mind. There's nothing wrong with that. Is the law by the state legislature a law enforced without the assent of the governor? How is that arisen? Then 145.3, then 142, then 131. All these questions, Mullahs, with the greatest respect, should not be answered. The only parameter that needs your lordship's careful consideration is Article 200 of the Constitution in the context of the power of the governor. Nothing else has arisen. So it's not about maintainability. It's your lordship's discretion in the exercise of your constitutional duty through a reference that is asked for to answer questions that your lord might wish to answer, might not wish to answer. Now, as I go back to my submissions, 2.5. Now, what is left? Well, I'm not going to argue 132 because I think it shouldn't be answered, Mullahs. I've done, Mullahs. I'm deeply, deeply obliged. I have, Mullahs, not repeated a single argument, and I have tried to save time so that my colleagues can argue.
But before my learned friend starts, on the lighter side, while arguing on the maintainability on the first day, Dr. Singhvi led the arguments, but my learned friend Mullah did not. But virtually he did that at the end in a different form, that it should not be answered because it is not made.
Some may be answered, some may not be answered.
No.
He is supported by judgment of the Supreme Court on that.
Yes.
Was referred to the judgment, Chandrajut's.
I will deal with that, Manoj.
You may
If you would have argued that at the outset, I would have dealt with that.
I never,
then.
in fact,
Now I will argue. We will not deal with those judges.
I never wish to argue maintainability because I don't believe that it is not maintainable. But I do wish to argue that many of these questions should not be answered.
Yes, Manoj.
And I am entitled to argue that.
How?
Then you may do it in the rejoinder.
In my rejoinder, Manoj. Without the flavor of my learned friend, I'll argue, my lord, straight
No, but
answering.
he has his own peculiar favor in every case,
Yes.
which we appreciate.
Yes.
Deeply obliged.
Obliged.
What has been decided by your side with regard to request of Mr. Anand? No, that is an issue to be decided amongst yourselves. So, yes, we finish it within an hour.
15 minutes. My Lord, I want to place the matter on behalf of the state of Karnataka on principles of constitutional interpretation. And I think, my Lord, the reference seriously entrenches upon one of the most acknowledged, consistent, and coherent principles of the Constitution, which is, my Lord, the democratic organ which enjoys executive power is the cabinet form of government. And this, my Lord, is central to the issue. Because if the cabinet form of government is the quintessence of a parliamentary democracy, which your lordships have upheld, reinstated, reiterated, right from, my Lord, 1954. And if that is so, then, my Lord, one has to discover what is the role of the president and the governor. Unless, my Lord, we have this picture clear, we will not be able to answer the question with reference to Article 200. My Lord, the law has taken a consistent position right from 1954 that both the president, governor are titular heads, and the true executive power resides in the cabinet, the ultimate cabinet, whether it is the union cabinet or whether it is, my Lord, the state legislature. In fact, my Lord, Dr. Ambedkar, very far-sightedly, in a speech of 26th of November 1949, amply clarified that both the central government and the state government, both the central legislature and the state legislature, have independence and are meant to be treated equally. I will not place that except from the speech. But, my Lord, there is a second principle on which your lordships will have to entertain this reference, which is the theory of collective responsibility to the House. Well, there are two principles. One is the cabinet form of government. The second is that cabinet form of government is collectively responsible to a legislature. Well, both these principles will be violated if either the governor or the president, my Lord, is given or is endowed with any form of discretion. If anything is to be indicated, my Lord, it has to be found in the text of the Constitution. For instance, my Lord, the president, after the 44th Amendment, by virtue of the first proviso under Article 74(1), can remit a matter to the cabinet for reconsideration. But after it is reconsidered, the advice is binding on the president. Under Article 103, my Lord, in respect of a disqualification, he is bound by the advice of the Election Commission. In order to discharge a judicial function about the age of a judge of the High Court, under Article 217(3), he consults only the Chief Justice and acts independent of the aid and advice of the Council of Ministers. These are the only two exceptions, my Lord, for the president. As far as the governor is concerned, my Lord, there are three sets of functions. The first is executive power, which is vested completely in the governor. The second is, my lord, he enjoys no legislative power. My lord, please take it from me. He enjoys no legislative power. The third is, my lord, functions for discretion are specifically nominated in the Constitution. And functions for reservation for consideration of the president are also identifiable in the Constitution. So, my lord, the question of high constitutional functionary enjoying plenitude of discretion, my lord, is completely anathema to the Constitution. And more than anything else, my lord, Keshwananda Bharati was resting on the pillars of the parliamentary form of government where the cabinet exercises the real power. In Keshavananda Bharati, your lordships equated the governor and the president in the constitutional sense in totally equal terms. So, my lord, I would submit with great respect that the first question for consideration is, what is the true relationship of the president and the governor to the cabinet government? This is the first question. And it is only then, my lord, we can come to the second one relating to Article 200.
Should we start at 2 o'clock?
Very well. I beg your lordship's leave, my lord, to resume. My lord, I wanted to place before your lordships an important excerpt from Dr. Ambedkar's speech, because I think it's of critical importance. I've handed over a copy of that speech. And if your lordships will kindly come to printed page 8950, it's volume Roman 4, serial number 24. Volume 4, item 24, my lord. And I'm inviting your lordship straight away to the passage, which is at page 8950. Lord, if your lordships will kindly look at a paragraph, the second paragraph in the middle of the page, there is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities. It is clear that this view is not only an exaggeration, but is also founded on a misunderstanding of what exactly the Constitution contrives to do. As to the relation between the center and the states, it is necessary to bear in mind the fundamental principle on which it rests. The basic principle of federalism is that the legislative and executive authority is partitioned between the center and the states, not by any law to be made by the center, but by the Constitution itself. This is what Constitution does. The states under our Constitution are in no way dependent upon the center for their legislative or executive authority. The center and the states are co-equal in this matter. It is difficult to see how such a constitution can be called centralism. It may be that the Constitution assigns to the center too large a field for the operation of its legislative and executive authority than is to be found in any other federal constitution. It may be that the residuary powers are given to the center, not to the states. But these features do not form the essence of federalism. The chief mark of federalism, as I said, lies in the partition of the legislative and executive authority between the center and the units by the Constitution. This is the principle embodied in our Constitution. Well, this is a beacon passage, if I may say so, which sheds light and illumination on how to interpret the various provisions in our Constitution. Now, my Lord, let me place straight away a judgment of your lordships. It is in volume 2, page 813. Volume V2, my Lord, page 813. Roman 5.2, my Lord. My Lord, incidentally, the first case relating to executive power arose, my Lord, in the Allahabad High Court. It was in the case of Motilal versus State. It went before a bench of 5 learned judges. Chief Justice Bidubhushan Malik, who was the Chief Justice, my Lord, of the High Court, along with Justice Sapru, Justice Mutham, Justice Vanchu, by a majority opinion held that the executive power of the state and the union was in fact the vast residuum of power after subtracting the legislative and the judicial power. This, my Lord, was cited with approval in Ram Javaya Kapoor's case. Would your lordships kindly come to, my Lord, volume V2 and straight away look at the relevant passage, my Lord. Please come to para 14 at printed page 827. Para 14.
Page?
My Lord, this is page 827. it may not be possible to frame an exhaustive definition of what executive function means and implies. Sorry. Your Lordship. Ordinarily, the executive power connotes the residue of governmental functions that remain after legislative and judicial functions are taken away. The Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently, it can very well be said that our Constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. Now, my Lord, please turn over the page to para 15. Your Lordships kindly look at Placitum B, the second sentence. Our Constitution, though federal in its structure, is modeled on the British parliamentary system, where the executive is deemed to have the primary responsibility for the formulation.
Where are you reading?
Well, para 15, second sentence. Our Constitution, though federal in its structure, is modeled on the British parliamentary system, where the executive is deemed to have the primary responsibility for the formulation of governmental policy and its transmission into law, though the condition precedent to the exercise of this responsibility is its retaining the confidence of the legislative branch of the state. Then, my Lord, in para 16, your Lordships may notice the second sentence. Under Article 53(1) of our Constitution, the executive power of the Union is vested in the President. But under Article 75, there is to be a Council of Ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. The President has thus been made a formal or constitutional head of the executive, and real executive powers are vested in the ministers of the cabinet. The same provisions obtain in regard to the government of states. The governor or the Raj Pramukh, as the case may be, occupies the position of the head of the executive in the state, but it is virtually the Council of Ministers in each state that carries on the executive government. In the Indian Constitution, therefore, we have the same system of parliamentary executive as in England, and the Council of Ministers, consisting as it does of the members of the legislature, is, like the British cabinet, a hyphen which joins a buckle, which fastens the legislative part of the state to the executive part. The cabinet, enjoying as it does a majority in the legislature, concentrates in itself the virtual control of both legislative and executive functions. And as the ministers constituting the cabinet are presumably agreed on fundamentals and act on the principle of collective responsibility, the most important questions of policy are all formulated by them. Well, this is, if I may say so with great respect, relevant because one needs to understand why is the governor and the president endowed with the authority to give assent to legislation. Well, that was something which your Lordships were inquiring of us. The reason is, my Lord, if all executive power is vested in the president and in the governor, there must also be an imprimatur for certification in relation to the bills which are passed by the legislature. My Lord, as rightly pointed out, neither the president nor the governor, even though they are stated to be a part of parliament and the state legislature respectively, ever participate in the affairs of the house. They do not have the right to vote. They do not have the right to participate in its deliberations. The messages which are, my Lord, sent to the house by the president or the governor are messages which are, my Lord, on the aid and advice of the Council of Ministers, including, my Lord, the message of returning a bill or reconsidering the matter by the House. I'll make it good, my Lord, in a little while. So in other words, my Lord, at all points of time, the president and the governor do not have any kind of discretion for the purpose of dealing with either the executive government or the acts of the legislature. The reason, my lord, why I'm mentioning this is, it is on account of this interpretation that in Keshavananda Bharati, the majority took the view that if there are implied limitations on the amending power, because the governor and the president are only eo nomine the constitutional heads, and parliamentary democratic form of government is the method we have adopted for the purposes of popular representation. That is how, my lord, the theory of implied limitations on amending power was discovered. I'll just place that, my lord, in a moment. My lord, the next judgment I wanted to place for your lordship's consideration is Sanjeevi Naidu. My lord, that your lordships will find is V49, Roman 549. Well, this judgment is significant because I'll then indicate, my lord, how in fact the law developed at that point of time. So please kindly see at printed page 18954.
Page 1A.
Well, does your lordship have the fourth line, a minister? Right from the top of that page, 18954.
52.
18954, my lord. I'm taking your lordship straight to the relevant passage. So, my lord, the reason why assent is required, my lord, by the president and the governor is because all executive action, my lord, under Article 77(1) and 166(1) has to be taken in the name of the president and the governor. That is why, my lord, your lordships will now notice a minister can only deal with the business that has been allocated to him.
Paragraph?
My lord, this is para 3,
Fourth line.
the fourth line from the
No,
top.
a minister can only.
A minister can only deal with the business that has been allocated to him by the governor under the rules. He is not competent to deal with any other business. Motor Vehicles Act has been allocated to the Home Department. Mr. So-and-so transport minister was not in charge of the Home Department. Therefore, his department could not have dealt with functions arising under the Act. Well, this was the submission. And then your lordships will kindly notice para 8. It was urged on behalf of the appellants that the Parliament has conferred powers under Section 68C of the Act to a designated authority. That power can be exercised only by that authority and by no one else. The authority concerned in the present case is the state government. The government could not have delegated its statutory functions to anyone else. The government means the governor, aided and advised by his ministers. Therefore, the required opinion should have been formed by the minister to whom the business had been allocated by the rules. It was further urged that if the functions of the government can be discharged by anyone else, then the doctrine of ministerial responsibility, which is the very essence of the cabinet form of government, disappears. Such a situation is impermissible under our constitution. We think that the above submissions advanced on behalf of the appellants are without force and are based on a misconception of the principles underlying our constitution. Under our constitution, the governor is essentially a constitutional head. The administration of state is run by the Council of Ministers. But in the very nature of things, it is impossible for the Council of Ministers to deal with each and every matter that comes before the government. In order to obviate that difficulty, the Constitution has authorized the governor under sub-article 3 of Article 166 to make rules for the more convenient transaction of business of the government of the state and for the allocation amongst its ministers, the business of the government. all matters excepting those in which the governor is required to act in his discretion have to be allocated to one or the other of the ministers on the advice of the chief minister. So, my lord, the rules of business which are framed under Article 77.3 and 166.3 are the rules which establish, my lord, the link between the action in the name of the governor and the manner in which, my lord, the executive will function under those rules. Now, my lord, the next judgment I wanted to place for your lordship's consideration, my lord, there's one more sentence in para 10. The first sentence in para 10. The cabinet is responsible to the legislature for every action taken in any of the ministries. That is the essence of joint responsibility. Your lordships have already noticed, my lord, for the president, there is a provision for impeachment under Article 61. There is no corresponding provision for the governor because he holds, my lord, office at the pleasure of the president. Then please see the next sentence, my lord. That is the essence of joint responsibility. That does not mean that each and every decision must be taken by the cabinet. The political responsibility of the Council of Ministers does not and cannot predicate the personal responsibility of the Council of Ministers to discharge all or any of the governmental functions. Since an individual minister is responsible to the legislature for every action taken or omitted to have been taken in his ministry, this again is a political responsibility and not personal responsibility. So, my lord, there is no concept of subjective responsibility in the Constitution. It is either political responsibility exercised by the executive government through the chief minister and the ministers, and, my lord, servants who are subordinate to them, the civil servants subordinate to them. And that is how, my lord, action is taken in the name of the governor. My lord, in R.C. Cooper versus Union of India, my lord, volume V.34, 5.34, my lord, there is a para which indicates, my lord, that even ordinance-making power is on the aid and advice of the Council of Ministers. So, my lord, although it is called legislative power, but in sum and substance, my lord, it partakes of the character of executive power, but it's on aid and advice. If your lordships will kindly see that for a moment, please see R.C. Cooper, only one para, my lord, page 13183, para 18A. Volume V.34, my lord. It starts at 13156, but the relevant para is 13183.
There is a doubt about all this.
No, my lord, there is no. I am only indicating, therefore, my lord, there has been a suggestion in the submissions of the Union of India that the president and the governor exercise discretion. My lord, that is fundamentally flawed. I'm submitting for your lordship's consideration. Once we answer this question correctly, then your lordships would be able to appreciate whether there is any vestige of discretion in the matter of a bill or the assent, which, my lord, I'll just now quickly come to. Now, please see para 18A, page 13183, my lord. (5.34), my lord. Please see in para 18A. Under the Constitution, well, this is just at printed page 1383, bottom.
1383.
Under the Constitution, the president, being the constitutional head, normally acts in all matters, including.
So you are reading para?
I'm so sorry.
18.
18 capital A.
Yes, 18.
Under the Constitution, the president, being the constitutional head, normally acts in all matters, including the promulgation of an ordinance on the advice of his Council of Ministers. Your lordship finds that, my lord? Whether in a given case, the president may decline to be guided by the advice of his Council of Ministers is a matter which need not detain us. The ordinance is promulgated in the name of the president and in a constitutional sense on his satisfaction it is in truth promulgated on the advice of the Council of Ministers and on their satisfaction. The President is under the Constitution, not the repository of the legislative power of the Union, but with a view to meet extraordinary situations demanding immediate enactment of laws, provision is made in the Constitution investing the President with power to legislate by promulgating ordinances. Now, my lord, I come to UNR Rao. My lord, that is important. Again, my lord, I'm indicating the importance of the cabinet form of government. And the cabinet form of government is relevant, my lord, to determine the ambit of discretion of the President and the Governor. And therefore, if the principle of collective responsibility is owed by the cabinet to the legislature, my lord, the Governor is outside both these. The Governor is outside a cabinet. The Governor is not collectively, is not in any way responsible, my lord, to the legislature. The Governor is responsible only, my lord, to the Constitution and to the oath of office and to the courts. But, my lord, otherwise, he is not responsible to the legislature in any way. Now, in UNR Rao, my lord, again, this question arose. And the court said, our Constitution never contemplated, even for a single moment, that there would be no Council of Ministers. Even after, my lord, the dissolution of Parliament under Article 75, my lord, Chief Justice Sigri read Article 75.1, 75.2, and 75.3, my lord, in harmony to say that there shall always be a Council of Ministers, and that is the mandate of the Constitution. So, my lord, that is the position as far as UNR Rao is concerned. May I request your lordships to just note the relevant paras. I don't need to read them. They are paras 3, 6, and 7, and 9, my lord. And para 9 clearly says,
What is the address?
oh, my lord, the address is B34, Roman 534. It starts at, my lord, page 13276. The relevant paras are 3, 6, 7, and 9.
Volume, V?
3, 6,
No, volume.
volume, my lord, B34.
Same volume.
Roman 534, page 13276. The relevant paras are, my lord, 3, 6, 7, and 9. And in 9, my lord, there's a reference to aid and advice of the Council of Ministers. So, my lord, aid and advice of the Council of Ministers is, my lord, central to our constitutional democratic governance. So, my lord, there are different forms of democracy. You can either choose a presidential form or you can choose a parliamentary form. We have chosen, my lord, a parliamentary form, both in terms of the center and in terms of the state. And that is why, my lord, the element of aid and advice is so central to the Constitution. So when, my lord, under Article 163.1, that expression in his discretion under provisions by or under the Constitution, there are specific provisions. The reservation, my lord, for the President also takes place only on the aid and advice of the Council of Ministers. So, my lord, a law which needs the assent of the President under Article 31A, 31C, 254.2, 288.2, all of them, my lord, they are reserved by the Governor for the consideration of the President for his assent. It is also only by aid and advice of the Council of Ministers. So, my lord, there is no position in the Constitution where the Governor acts in his own discretion, except, my lord, in two cases. One, when he submits a report to the President under 356, or when he, my lord, takes a position contrary to the position of his cabinet in assenting to a law which detracts from the jurisdiction of the High Court. These are the only two positions, my lord, apart from those special provisions in Article 371 A, D, E, F, G, H, I, and, my lord, para 6 schedule, paras 20 BB and 20 AA.
The paragraph you are relying on in.
Yes, now, my lord, I'm coming to Keshavanand.
3, 6,
7 and 9.
No, you are not wrong.
Oh, in UNR Rao. I'm sorry, my lord. In UNR Rao, paras 3, 6, 7, and 9. Lord, your lordships may take it. I'm stating the proposition accurately. from the judgment. So I'm proceeding to the next one. Well, this is an important judgment because what the submissions of the union seek to do is, my lord, indirectly abrogate, shall we say, the fulcrum of the constitution, which is the cabinet form of government and the responsibility to the legislature. My lord, in Keshavananda Bharati, the judges wanted to consider whether Article 368 had any limitations. Well, there were no express limitations, but they wanted to examine whether there are any implied limitations on the amending power. To discern, my lord, a limitation on the amending power of Parliament, they said, if under our constitution, the president and the governor, who seem to enjoy untrammeled discretion if you go by the words of the articles, like on his satisfaction, in his opinion, but in truth and substance, they have very limited power. Because they have very limited power, the court said, we believe that there is something called implied limitations. So even though the express words in relation to the governor and the president, again, my lord, to borrow the language of the learned solicitor, indeed suggested some sort of plenitude of powers, but they said no. In substance, the governor and the president stand on the same footing, and because we see this limitation, therefore, this is a part of the basic structure. What is a part of the basic structure? That is the democratic form of government through a cabinet is a part of the basic structure. And they said no amendment can be passed. Well, I'm the majority opinion. Took the position it cannot be passed. Well, the theory of implied limitations was noticed by Chief Justice Sikri, Chief Justices Shelat and Justice Grover, Justice Hegde and Justice A.K. Mukherjee, and Justice Jagan Mohan Reddy, who read it slightly differently. Justice Khanna took the view that if you attempt to change the form of government, that's a democratic form of government, then in that case, it is a case of abrogation of the Constitution, which is outside the amending power. Well, Lord, it's a long judgment. I can give your lordships the relevant paragraphs from your court record. But, my lord, they make instructive reading because the suggestion of the union, one, they say there is a unitary bias in favor of the center. Well, Lord, it is true there are additional powers in favor of center and parliament, but, my lord, there's nothing called unitary bias. Second, my lord, there is nothing called discretion. My lord, a claim has been made that there is discretion both in the president and, my lord, in the governor. That is not true, my lord. I have indicated that prior to the 42nd Amendment in Article 74, my lord, the provisions of Article 74(1) were identical to Article 163(1), except for the words, my lord, in his discretion. Otherwise, the words were identical. And in relation to the unamended article, in Shamsher Singh, because of Malot Sardari Lal's case and Babu Ram Upadhyay, these two judgments, they came to the conclusion that aid and advice means it is binding. So in S.P. Gupta's case, Justice Bhagwati said that although we had laid down the principle in Shamsher Singh, that has received a constitutional recognition by the insertion of the proviso in 74(1). And 74(1), my lord, made aid and advice binding on the Council of Ministers. That is noticed, my lord, in S.P. Gupta's case. Therefore, my lord, if you want to see anything of discretion, we have to discover it in the Constitution. My lord, please see, I'll give your lordships, the volume is, there are two volumes, my lord, V.50 and V.51. Well, I gave the Supreme Court reports. Well, I gave that because the summary, my lord, is accurate. But if at any time your lordships, well, I'm giving the relevant paras for your lordship's kind consideration. My lord, this is the authorized, at that time, my lord, we used to treat it as the authorized version.
We could have taken the book.
My lord, this is V.50. And if your lordships will kindly come to page 19309, your lordships will find Chief Justice Sikri's opinion.
19?
19309, my lord. And
19309.
309. And may I take your lordship straight away? 19. My lord, after citing Ram Jabaya Kapoor in 19309, this conclusion, after my lord Ram Jabaya Kapoor, Sanjeevi Naidu, please see this conclusion. Your lordships
Yes.
find that para, my lord? This conclusion constitutes an implied limitation on the powers of the president and the governors. So, my lord, if in Keshavananda they read these powers as so limited by its very nature, I submit, my lord, we cannot now read into these provisions an element of discretion. And my lord, 19425, your lordships will find the opinion of Justice Shellett and Justice Grover.
194?
25. In 19425, my lord, your lordships will find in the middle of the second paragraph, it has been implied that the president has been made a formal or a constitutional head of the executive, and the real executive power rests in the Council of Ministers and the Cabinet. Then, my lord, the articles are recited. Then your lordships will notice the minister shall hold office during the pleasure of the president, and the Council of Ministers shall be collectively responsible to the House of the People. Then your lordships notice this conclusion, which is based on the implications of the cabinet system of government, can be said to constitute an implied limitation on the power of the president and the governors. Well, to the same effect, your lordships will notice is Hegde and Mukherjee are JJ. Well, Justices Hegde and Mukherjee, which your lordships will find is at PDF, page 19473, my lord. The opinion begins. The relevant portion, my lord, is 19484. 19484. Several of the powers conferred under our Constitution have been held to be, my lord, page 19484. My lord, this learned judge, Justice Mukherjee, my lord, he demitted, he passed away, my lord, in harness. No, my lord, this is Arun Mukherjee. This gentleman, my lord, he would have been the Chief Justice, my lord, but unfortunately he passed away during the summer recess when he was a vacation judge. Several of the powers conferred under our Constitution have been, sorry, my lord, 19484.
Justice Scheller and
This is, no, my lord, Hegde Mukherjee.
they reiterated that they did not ask the General Advocate General for State of Maharashtra, who was leading the arguments, to address on this issue in detail. So, because the main issue was with regard to the amending clause of the Constitution.
I quite see that. Now, please see, my lord, Justices Hegde and Mukherjee. Please see this at just after the quotation in James versus Commonwealth of Australia. Several of the powers conferred under our Constitution. Does your lordship find that?
Yes.
Several of the powers conferred under our Constitution have been held to be subject to implied limitations, though those powers are expressed in general terms or even in absolute terms. The executive power of the Union is vested in the President, and he is authorized to exercise the same, either directly or through officers subordinate to him, in accordance with the Constitution. Under Article 75, it is the President who can appoint the Prime Minister, and the officers are to hold office during his pleasure. Despite this conferment of power, in general and absolute terms, because of the scheme of the Constitution, its underlying principles and implications arising from the other provisions in this Constitution, this court has held in several cases that the president is a constitutional head and the real executive power rests in the cabinet. Similarly, though plenary powers of legislation have been conferred on Parliament and the state legislatures in respect of the legislative topics allotted to them, yet this court has opined that by the exercise of that power, neither Parliament nor the state legislatures can delegate to other authorities their essential legislative functions, nor could they invade on the judicial power. These limitations were spelled out from the nature of the power conferred and from the scheme of the Constitution. So, my lord, I submit with respect, my lord, Justice Khanna's opinion, my lord, is at page 19919. My lord, this is volume V.51. It's the second volume.
My lord, 19919.
19991.
No, my lord, 19919. Please see, my lord, the last paragraph. In the last para, my lord, this brings in the concept of federalism because you have dual governments, one in the center and one in the state. In a federal system, does your lordship have that passage, my lord? It's the last paragraph. In a federal system where the spheres of legislative powers are distributed between the central legislature and the state legislatures, there has to be provided a machinery to decide, in case of a dispute, as to whether the law made by the state legislatures encroaches upon the field earmarked for the central legislature, as also a dispute whether a law made by the central legislature deals with a subject which can be exclusively dealt with by the state legislatures. This is true not only of a federal system, but also in a constitutional setup like ours, which the constitution makers, though not strictly adopting the federal system, have imbibed the features of a federal system by distributing and setting apart the spheres of legislation between the central legislature and the state legislatures. The machinery for the resolving of disputes as to whether the central legislature has trespassed upon the legislative field of the state legislatures, or whether the state legislatures have encroached upon the legislative domain of the central legislature, is furnished by the courts, and they are vested with the powers of judicial review to determine the validity of the acts passed by the legislature. The power of judicial review is, however, confined not merely to deciding whether in making the impugned laws of the central or state legislatures have acted within the four corners of the legislative list earmarked for them. The courts also deal with the question as to whether the laws are made in conformity with and not in violation of the other provisions of the Constitution. Our Constitution makers have provided for fundamental rights in Part 3 and made them justiciable. Now, my lord, before I cite one important passage, my lord, in Shamsher Singh, there is, my lord, a debate, a speech in the Constituent Assembly debates of Sir Alladi Krishnaswamy Iyer. There is a reference, my lord, to the speech in Justice Krishna Iyer's concurring judgment, where, my lord, the speaker says that if a president acts in his discretion and does not abide by the aid and advice of the Council of Ministers, he is thwarting the will of Parliament. Now, that is the principle of aid and advice. That it is by that method you actually secure what is called parliamentary accountability. And my lord, this is the basis in Shamsher Singh's case. Why? Because, my lord, up to this point, there were, my lord, two judgments which took the view that all these articles gave personal discretion. That is, President had discretion to declare emergency. President had discretion to declare financial emergency. President had discretion to dismiss anybody at pleasure, my lord, under Article 310. When all this was there, in Sardari Lal, my lord, they said all these are discretionary provisions. And that, my lord, was actually set right in Shamsher Singh's case. In Shamsher Singh's case, they relied upon two previous judgments, my lord. One of Bijay Lakshmi Cotton Mills, and the second one, my lord, was the Bijay Lakshmi Cotton Mills, and my lord, the judgment in Motiram Dekar. My lord, Motiram Dekar overruled Bapuram Upadhyay. On that basis, my lord, in the judgment in Shamsher Singh, my lord, I'm giving a summary because it's very accurate to see this reasoning. The view expressed by Chief Justice Ray in the majority judgment, my lord, proceeds on the footing executive power is vested only in the president and the governor. And, my lord, except for those two provisions and specific provisions, he says they are identically placed and they are bound by aid and advice at all points of time. My lord, that is very significant in this judgment. Now, how is it, my lord, Chief Justice Ray comes to this conclusion is very interesting. He says, under Article 77.3, you make rules of business. Through rules of business, the governor actually acts. Those rules of business are also, my lord, on aid and advice. The rules of business which were framed by the president and the governor are themselves, my lord, products of aid and advice by which, my lord, ministerial allocation of business can be suitably defined. So, my lord, in Shamsher Singh, their lordship said that because of this constitutional scheme of 77 and 166, 77.3, 166.3, 77.1, 166.1, we must necessarily come to the conclusion that it is aid and advice which is binding on the Council of Ministers. In other words, they said, and my lord, the two learned judges have expressed two different expressions. Chief Justice Ray says you cannot have a parallel administration for governor. My lord, Justice Krishna Iyer and Justice Bhagwati, they said there would be something called a diarchy, which would itself be an anathema to the Constitution. I'll only give the para numbers, my lord, because the judgment has been read over and over. I will only give your lordships the para number, yes, and I'll just make a mention. My lord, please see this is in volume V.7. Shamsher Singh, page 2886. And my lord, paras 17 to 19, 2886, my lord. And in paras 17 to 19, their lordships actually, my lord, notice that the expression in his discretion was consciously deleted. I'm only giving the para numbers, my lord. Para 17 to 19 and para 20.
Paragraph?
Paragraph 17-19, my lord. Paras 20 and 25. And then, my lord, para 26, which is very important, my lord. They say the president and the governor never exercise this power personally. So even though the words satisfaction, opinion are written in the Constitution, but they never exercise these powers personally. They only exercise it on the aid and advice of the Council of Ministers. And, my lord, in paras 27-28, they describe the cabinet system of government and how they are the formal heads of state.
Titular heads.
Yes, that, my lord. This is the position. And, my lord, may I also request your lordships to note para 48, 54 to 56 has already been read, my lord. And Justice Krishna Iyer, my lord, I want to show this important statement of para 109. Sir Alladi Krishnaswamy Iyer's statement at page 2918. My lord, that is an important sentence because that establishes 2918, my lord. (2918).
Paragraph.
My lord, your lordships will notice
918 is
paragraph 109, my lord.
109.
109. Please see that, my lord. This is Sir Aladi Krishnaswamy Iyer in the Constituent Assembly. It was provided in the Constitution that the Council of Ministers would be collectively responsible to the House of the People. If a president stood in the way of the Council of Ministers discharging that responsibility, he would be guilty of violation of the Constitution and would even be liable for impeachment. It was therefore merely a euphemistic way of saying that the president had to be guided by the advice of his ministers. The Council of Ministers were collectively responsible to the House of People, answerable to the House in regard to the budget or legislation, and indeed for every matter connected with the administration of the country. Then, my lord, please see, on another occasion he reiterated, the Union Constitution Committee and this assembly have all adopted what we may be called the cabinet system of government. An infant democracy cannot afford under modern conditions to take the risk of perpetual cleavage, feud, or conflict or threatened conflict between the legislature and the executive. So, my lord, this gives your lordships an overview. My lord, my colleague, Mr. Anand Sharma, he is somewhat severely constrained. He is not in a position to appear on the next occasion when your lordships assemble. I thought, my lord, if your lordships do not consider it inappropriate, may I, my lord, pause here and allow him to urge his submissions, my lord. I think out of abundant respect, I do owe this to Mr. Sharma. And I will resume, my lord, and complete my submission on Tuesday.
How much more time?
My lord, I'm going swiftly, my lord. I'm coming to the next point. There are 2 points. And I won't, my lord, in fact, I will not even take the fully requested time. I would take an hour at the maximum. I just want to place this, my lord, in some context.
He concludes. Can you take over after him today?
Certainly, my lord. I'm
In any case, you are here only. You are the only person who has been constantly here.
not going to leave.
You are the only person who has been consistently and constantly here. And if you go by Mr. Sibul's advice, Dr. Singhvi would not get a chance to address.
I'm an old fossil, my lord. I'm grateful, my lord. May I, my lord, hand over
Yes.
to my learned friend, Mr. Sharma. I'm grateful to your lordships.
My lords, I represent the state of Himachal. I'm deeply obliged the consideration shown, and it's an honor to have an opportunity to make these submissions. At the outset, I would like to express my deepest appreciation and gratitude also to Shri Gopal Subramanya for being gracious in accommodating, as your lordships have been very kind. My lords, this presidential reference does seek to reopen many settled issues of law, and at the same time has brought into question and discussion foundational constitutional issues of critical import. This honorable court has already addressed, lords, the question of maintainability, and many learned colleagues have spoken on both the sides. So I feel that save time, have very little time. It needs no revisiting as what has been said on this. We have made written submissions and the judgments relied upon that may kindly be taken as read. We have given a short note today, which has been circulated, and that is volume 2, Roman 2.7. And along with that, we have attached some very relevant authorities in volume 4.25. I seek to focus, my lords, only on few points. First is federalism, the power, responsibility, and the rights of the union, and the autonomy of the states. Second, the position, powers, and constitutional role of presidents and governors. Number 3, justiciability of decision on bills. 4, the discretionary powers of the president or the governor, separation of power, and the legislature, between the legislature, the judiciary, and the executive. My lords, it's well known that the framers of the Constitution, while grappling in framing the Constitution, it was a historic transition for this country. After centuries of subjugation, for our people to be given a voice, and therefore they were equally conscious that India is a country rich in diversity, multilingual, multi-religious, multi-ethnic, with each region having its own distinct history. I need not dwell more, your lordships are aware. So in their collective wisdom, they decided, and our people decided, those who were well informed of the conditions during the national movement, to make this country a union of states and a parliamentary democracy. The framers of the Constitution, in their collective wisdom, have also put in a place of checks and balances between the executive, legislature, and the judiciary to perform constitutionally assigned functions which remain distinct yet interlinked. There's no firewalls here when it comes to the separation of powers. I was thinking this morning, sitting here last few days, returning to the bar after 2 years back, I came back after a long gap, that it's so beautiful.
We should have followed Dr. Singhvi, Mr. Sibal.
I was,
Nobody stopped you from that.
no, I,
Mr. Wilson,
situation and circumstances.
Mr. Wilson, Mr. Reddy.
I wish if I had their wisdom and their energy, because I believed in one thing. When I was given responsibilities to focus seriously on lawmaking, to do my work. So, Lord, if I'm allowed
So,
indulgence.
you mean to say that they are not serious?
No, I'm not saying, sir. I'm saying, sir, I lack their wisdom and their energy. No, I'm not saying that, please. Well, whatever. What I'm saying, it's a great honor to be back to the profession to which I belonged. My late father, who was an illustrious, eminent lawyer, he belonged to this profession, and he never approved of the other passion, what kept me away. It's a tribute to my father also today. My lords, Lord, the doctrine of separation of powers, as I was mentioning, is not an abstract, but the very foundation of India's constitutional framework. I don't have to repeat how the lawmaking takes place. My very eminent colleagues have referred to that in detail. But it is the legislature which is sovereign, the parliament or the state legislature, when it comes to lawmaking. When it comes to interpretation, your lordships are the final arbiter. You have to adjudicate what is within the four corners of the Constitution and what is in conflict with that. And that's why India's democracy and the constitutional democracy has sustained itself, whereas many other countries in Asia, Africa, Latin America, which became independent along with us, could not sustain their democracies, could not uphold the citizens' rights. And this is the strength of our republic, my lords. Article 50 of the Constitution has ensured judicial, and therefore, that is what matters to the people of this great country, that their rights, as enshrined in the Constitution, are secure, justiciable. They'll get a fair treatment, and their dignity as the citizens of the Republic shall be protected. The President and the Governors, my lords, the issue that has been raised, whether they have any discretion, answer is no. Constitution actually does not give any discretion. Even what is mentioned here in few articles, where the bills passed by the Assembly, there is holding of assent by the Governor, and they are referred to the President for consideration. That's also stipulated strictly by the Constitution. Is no discretion or prerogative which was dispensed with in the Constituent Assembly. It was there in the draft that was submitted and discussed, the draft Article 91, but that was done away with, and the amendment to do that, and also to Article 200 to ensure that there was no delays, moved by none other than Dr. B.R. Ambedkar. We have quoted in our submissions in detail as to how strongly he felt, how strongly the other learned colleagues in the Constituent Assembly felt. The powers, therefore, of the President and the Governors are de jure, not de facto. The executive power is vested entirely in the Cabinet, in the Council of Ministers. The powers to, I'm coming to Article 200, powers to withhold assent, as your lordships know, 2 is conditional. And it's even in the case of recommending bills under Proviso 2 of 200 for the consideration of the President, only a bill, it becomes a law, so derogates from the powers of the High Court as to endangers the position which that court is by this Constitution designed to fill, or as specifically
Yes,
my lords.
Yes.
I was saying that the proviso is very clear that where the Governor would recommend or send it to the President. In other cases, as specifically stipulated, is Article 31(3) the property acquisition law, which have been discussed and read here, is there in our submissions, Lord. Second proviso of Article 200, which I was referring to, Article 2882, second proviso, the state taxation of interstate river, water, and electricity. Article 304B, any restriction on freedom of trade between states. Or 360, a financial emergency. Discretion of the governor does not exist in our constitution. That is the real situation.
That's all. Everybody is on the same page on this side.
Yes, yes, yes. That's why I'm not elaborating. Lords, the Article 200, as soon as possible, the correct interpretation, ideally, as has been submitted here, means at the earliest. That would be the right way to interpret.
Mr. Sibal has gone forward. He has said forthwith.
Well, my lords, in the draft that was before the Constituent Assembly, as your lordships know, there was a provision, suggestion, or proposal of 6 weeks that was dispensed with and rejected. Not accepted.
Not rejected. It was not there in the final draft.
It was not there because it was made clear that there is no room for delay in lawmaking. Going through the debates, it was there in the draft. I've said it was discussed also. But finally, that 6 weeks was considered to be a bit longer, not shorter. When we are talking today, here we are talking of 6 months, 8 months, 1 year. That is where the present discussion is. And that's where your lordships are seized of this reference and the matter. My lords, even in United Kingdom, the sovereign originally had the power to withhold assent. And it's the Supreme Court in the United Kingdom which termed it unconstitutional. Our governors have a role, constitutional role, so well defined. But if we say that they have the discretion to withhold, or this concept which has been very well explained by many colleagues of the bill falling, which does not exist, which has quite perplexed governors, with due respect, I'll submit, are not viceroys or governor generals. They are governors under our constitution, who are bound by the aid and advice of the Council of Ministers. I'm referring to 64 and articles and 173 is in our note that has been given to your lordships. That is from pages 1101 to 1105. I am also bringing to your lordship's attention some very important articles which have so far not been referred to further underscore the submission that legislature is supreme. Neither the president nor the governors actually have any role in lawmaking. They are not part of the legislature. For both the president, the parliament starts in the constitution with the president, and the legislature starts with the governor. But even when they come to the parliament to address the joint session or to, in the assembly, the governor, my lords, they don't preside, they don't share, they only address. I'm coming to that. And taking it straight to Article 85, the convening of the sessions of the Parliament is in pages 1101 of the volume 2.7 onwards. It deals with the convening, adjournments, prorogation, and the ordinance making. According to Article 85, the President shall from time to time summon each House of Parliament to meet at such time and place as he thinks fit. But 6 months shall not intervene between its last sitting in one session and the date appointed for the first sitting in the next session. And then, by the two, the President may from time to time prorogue the House or either House. In case of legislature, the same apply under a different article, and that in this case is 174. No, 174 is there. The power to summon the Lok Sabha, my lords, is vested in the President. He exercises this power on the recommendation of the President. Proposal to summon the Parliament, and the same would apply, my lords. The summoning of the State Assembly or the legislature is initiated by the Minister of Parliamentary Affairs and submitted to the Prime Minister. And upon the Prime Minister's approval, the proposal as finally agreed to by the Prime Minister, formally submitted to the Speaker, who upon concurring or agreeing with the proposal, which normally is the practice, because the Prime Minister is the leader of the majority party, which is in government, then the Speaker, through the Secretary General, sends it to the Honorable President to summon the Parliament. Same applies to the state assemblies. And the summons are issued in the name of the President.
Your proposition, what your
My proposition is, my lords, if I come right up to the Article 86
on
message. Yes, my lord.
these articles, what is your proposition?
My proposition is that even to summon the legislature, the President or the Governor have no role. They are bound by the aid and advice
Of the
Council of Ministers on their own suo motu. They cannot summon either the Parliament or the legislature. I go a step beyond. Article 86, my lords. The President may address either House of Parliament. This practice evolved of the joint session later under Speaker Mavalankar when a constitutional amendment was necessitated. And it was felt that it should be once annually a joint address. The only departure being when an election to the Lok Sabha is held or a midterm election to the Assembly, then there is a departure. Otherwise, there is one address. Now, that address, which the President has submitted from pages 35 to 38 of my note, but 1105, 06 up to 08. It's important. What I was referring to earlier, and I draw your attention, I submit to call and Shakhtar, which we have submitted, page 181 of the Practice and Procedure of Parliament, the 6th edition, which makes it absolutely clear. Now comes the issue of the address. that is also approved by the cabinet, whether in case of governor or the president. The president or the governor cannot add, delete even one sentence or one idea. They speak on behalf of the Council of Ministers, the cabinet. Constitution makes it abundantly clear. It's in the name of my government the address is. And my government will do this, their policies, their priorities. Not I as president, not I as governor. And that is the practice, my lords.
Where do you get that from? From which articles you get that?
Article 86 is this, and call and Shakhtar, as I mentioned, page here.
The Kaul is here.
No, we have. Call and Shakhtar is these things that the president or the governor, that's what they speak, what they say, they address, is on behalf of the government. It's as cleared by the cabinet. If I go further, I had referred in detail about the summoning part. If I may also mention about the prorogation of the House, the termination of a session of the House by an order made by the President under Article 85(2) is called prorogation. And Call and Shakhtar say, page 189, Practice and Procedure of Parliament, they are the acknowledged authorities when it comes to legislature. The termination, volume 4.25, my lords. Prorogation of the House. Termination of a session of the House by an order made by the President under Article 85(2) is called prorogation. The President, in exercising the power to prorogue the House, acts on the advice of the Prime Minister. The Prime Minister may consult the Cabinet before the advice is submitted to the President. Prorogation of the House may take place any time, even while the House is sitting. Usually, however, prorogation follows the adjournment of the sitting of the House, sine die. That's on page 189. My lords, we have submitted. And what is the practice after adjournment is very. Once the President has made the order, it is notified in the Gazette Extraordinary on the same day. But when? When the Minister of Parliamentary Affairs sends a communication to the Speaker, and Speaker concurs, and through the Secretary General.
That the Kaul and Shakhtar may not be relevant for us while we are when we are interpreting the Constitution.
No, in one context.
We may be guided by the
Yes.
debates in the.
But I'm quoting, my lords, the articles of the Constitution.
The Kaul and Shakhtar may be relevant insofar as the procedure in the Parliament is concerned.
But what mentions
that may not guide us when we are interpreting the provisions of the Constitution.
In the Constitution itself, it's abundantly clear. The same thing, what I'm reading from there. What is the practice? Even on prorogation, also on ordinance, if we look at that, it's crystal clear. There is nothing new, which Call and Shakhtar is only referring to and reaffirming that this is how legislature functions when it comes to the summoning, the prorogation, the lawmaking, as well as the power to make ordinance. Now, that is important because when submit Article 123, my lords, power of President to promulgate ordinance, and the similar power in the Constitution also has for the governors. If at any time except when both houses of parliament are in session, the president is satisfied that circumstances exist which render it necessary for him to take immediate action, he may promulgate such ordinance as the circumstances appear to him to require. To him, my lordships, an ordinance promulgated. This is not a legislative power of the president. Same applies to the governor. Under the Constitution, it has very short life. It shall have the same effect and force and effect as an act of parliament, but all these ordinances go back to the parliament in the first sitting of the house, and within 6 weeks, if the government of the day does not want to retain the ordinance falls. There's no force of law then. Therefore, a bill is required under the Constitution to be brought. Government may bring the bill. The government may not bring the bill. It was said, if my memory serves me right, which is good, that it was the learned Solicitor General who referred to legislative powers. And I was listening very carefully, and my mind raced to what actually that meant, because it does not give any lawmaking powers to the president, to the governor at all. That's why I referred to, there was a reason why specifically my lordship this time to refer to Article 85, 86, 87, and Article 123, which has all been submitted, that right from the summoning to lawmaking, to the enactment of a law, amending the Constitution, President, and in the enactment of laws, the governor have no role. Yes, assent, which I have mentioned, and it has been submitted repeatedly by learned colleagues. It is very carefully carved out, specifically stipulated, does not give any discretion. My lords, I would like to submit that the federal structure, part of the basic structure of the Constitution, that is what we have. It has a unitary bias, which is designed to reconcile the autonomy of the states with the autonomy of the state, with the unity of the nation. The very first article starts by declaring us as a union of states. And that is what this reference under Article 143 brings to the fore very sharply. This federal structure of ours is the cornerstone of the Constitution. Both levels of the government, union and states, derive their authority, my lords, from our Constitution and operate within their respective sphere. The states have their autonomy. That's what the Constitution guarantees. Not that they become a separate autonomous away from the union, but that has to be borne in mind. And the center-state relationship is marked by a clear demarcation of powers, my lords. Duties and responsibilities are well defined constitutionally. Now, I'll skip some which are, feel that in our submissions, which are with the lordship, are enough. Our federalism is also India's strength. And many pronouncements of your lordships, which are referred to, have reaffirmed that federalism is part of the basic structure and of the Constitution, which cannot be eroded, diluted, weakened in any manner. Therefore, my lordships, any attempt to redefine or revisit will disturb the equilibrium between the union and the states and has its perils. reference was made on the day first itself by the learned Attorney General, if I'm correct, to the functional disharmony. These two words were used. This is genuine concern, a concern which I share, my lordships, but the functional disharmony between different authorities, whether it's between the executive or the parliament. The executive naturally either will survive or go, or with the judiciary. In our constitutional scheme of things, there is no room, there is no space, because that will actually erode our own strength. What has been discussed here on justiciability also is important, that what the governor has done by withholding the powers, not giving assent. Whether it's justiciable, the answer is a firm yes. There is no protection which is claimed, has been explained. It is, if there is a delay in lawmaking, if the governor withholds assent, my lords, question which comes is the office of the governor, which has a defined constitutional role. In certain situations, governor plays an important role. If there is a complete breakdown of law and order, or the machinery of administration and governance, or there is an external threat to the country, it threatens the unity and integrity of our country, the governor has a defined role. But does the governor have any authority to sit over bills passed by the legislature? That is what I'll say, functional disharmony and conflict. The governor's office cannot be used, my lords, to nullify the will of the people, which is supreme.
That's what has been argued by everyone.
Yes, that's what I'm saying, that it has been. I'm giving, but I'm just doing my duty by.
You are doing, but then as people said that.
No, some things new which I have said.
Repeat what has already been argued.
Yes,
We expect the-
that's why I have not quoted even one judgment, because all the judgments are the same.
These points have already been argued by everyone.
Yes, that's why I have
So if
avoided.
you want to address something,
No,
you
no,
are most welcome.
So that's why I have specifically referred to those articles of the Constitution. Specifically.
We appreciate that on 85 and 86.
Yes, up to 1 to 3, up to the ordinance.
Anything more that you would like to add to what has been already argued by Dr. Singhvi?
Yes, my lord, that is, my lord,
You know that
you have been
your side has
very
to-
kind.
This side has to complete by tomorrow. At the most 1.5 hours on.
Sure, my lords. I hear it very clearly. If I may say,
We'll go through
seeking
your
your
submission.
indulgence, I'll just make one comment. This is always the disadvantage of somebody who speaks low down the order.
No.
No, because of there is constitution cannot be, I can't rewrite the constitution. I'm only referring to what I feel is important. I can elaborate, but I'm conscious of the time. And as I said, I'm grateful that I have this opportunity to make the submissions. But what I would like to say, my lords, that this is where I won't go further. Any impermissible encroachment or by undermining the authority of the state legislatures cannot be and must not be allowed. That is what has to be protected at any cost. The states have their autonomy, that's our constitution gives, and they must not be belittled or disrespected. The fault lines are there. It is not in the interest of our country. If there is a perpetual state of disharmony, dysfunction, the states cannot be, because of the whims and fancies of the governors, for whatever reasons. If the reasons are constitutional, the that are specifically stipulated without any gray area. Those are very much there. But if that is not the case, then holding back. And that is the case with most of the states. If you have a situation where some states elected legislature, good majorities in their assembly, which is the will of the people, cannot make a law. I know of instances where the chief ministers express their helplessness. Even in case of universities for education. And this is true. We have the charts, but I don't want
We
to
have
have
to
given enough.
that we have made it clear in the beginning itself. Otherwise, Mr. Mehta has threatened us with a list from 1950.
Yes, but I'm not saying something. What is important is that the states, the legislatures, their position in our parliament, the states have their own position in our constitution. That has to be protected, respected. The states cannot be, my lords, either belittled or treated as municipalities that the state.
That's what Dr. Ambedkar replied to that criticism. Dr. Ambedkar criticized that
Yes.
the constitution lowers down the states to the level of municipality. He went with that allegation and explained. Someone has read that passage from the speech of 25th November 1949.
I was enthralled when he was quoting that speech, and his understanding depth, not only eloquence, but also, I'll say, intellect, is beneficial for all of us, I'm sure, my lords. And I've known Gopal Subramaniam ji for long, and that's why I find him as a person who is grace and also understands the depth, the challenges,
Because
and
you
the
are
seriousness.
enough to give a pause to his argument so as to accommodate it.
That's what I started with that. I'm ending with this, my lords. I'm grateful to you. Thank you. Thank you, my lords.
Wish you all the best for your
Yes, ma'am.
bidding
Thank
in
you.
your family.
Thank you. Hmm?
Lord, let me now come to the second point about 200, because that's the point which is engaging your lordship's attention. Lord, in Kameshwar Singh's case, there is a passage in Chief Justice Patanjali Shastri's judgment where he says that although the governor is a component part of the legislature, but he really is not a part of the legislature. It is a misnomer to think that the governor is a part of the legislature just because the constitution says he is one of the components or constituents of a legislature. Lord, the importance of that, my lord, is this, that if the governor is in a sense alien to the legislative business of a legislature, then his role is limited and circumscribed by aid and advice. Whether he wants to return the bill, whether he wants to reserve it for the consideration of the president, my lord, reserving a bill for the consideration of the president, my lord, is not discretion. It is under the various provisions of the constitution. It is under those provisions that, my lord, the aid and advice is given that please do forward this bill for consideration of the president. Even, my lord, when it goes to the central government, it is also, my lord, examined through the rules of business of the central government. So, my lord, rules of business which show aid and advice is always adopted, my lord, even for the purpose of a message to reconsider a bill under Article 200. So whether, my lord, whether he grants assent, whether he withholds assent and sends it back to the legislature for reconsideration, or whether he reserves it for consideration of the president, all take place, my lord, under the aid and advice of the Council of Ministers. My lord, in fact, all the judgments, if I may say so, except Pavitra's case, that's the only exception. Otherwise, my lord, all the judgments can be read with reasonable unanimity, and a uniform interpretation can ensue. That the intention was that in case you don't follow the procedure contained in the proviso and represent the bill to the governor, it falls through. Well, falling through literally means it falls. It falls because it's not being represented to the governor. So it is in that interstice, my lord, that the expression falling through has been used, which is why all the passages, my lord, they can be read unanimously. They almost are unanimous that a governor can assent. My lord, the words which are important in the proviso are, as soon as may be, upon the presentation of the bill. My lord, that's very important in the proviso. It shows that when you say that he is withholding assent, it means as soon as, my lord, it's presented to him, he has to act under the proviso in case he is not assenting. So, my lord, predominantly, the intention of Article 200 is to secure the assent of the governor, unless it is a case which requires the assent of the president. My lord, this is necessary because this is the only way in which all the provisions of the Constitution will completely coalesce. My lord, take the case in respect of the proviso to Article 111. It employs virtually the identical language as is contained in the first proviso to 200. If, my lord, under Article 111, the president is bound by the aid and advice of the Council of Ministers and sends back a particular bill for reconsideration on that basis, my lord, there cannot be a different yardstick for the purpose of interpreting the first proviso in Article 200. So, my lord, this synonymity of the nature of the function of the president and the governor is, my lord, central to the theme of aid and advice. And that is why, my lord, I submitted that these are the three steps. First is to determine the cabinet form of government. Second, it runs by aid and advice. And, my lord, the governor and the president are titular heads. The reason, my lord, why assent is required from the president is your lordships have seen that all executive action is taken in the name of the president under 77(1). All executive action is taken in the name of the governor under 166(1). Therefore, my lord, even for the legislative business, the act of assent from the head of state is sought. That is, my lord, the design as far as the Constitution is concerned. My lord, to intervene by any process in this, it must be one which is authorized by the Constitution. My lord, that is why, where, my lord, he has discretion. Suppose, my lord, a governor is appointed as a governor of an adjoining union territory as an administrator. There, my lord, the Constitution clearly says, Article 239(2), that he will act independent of the advice of the Council of Ministers, because, my lord, a union territory does not have a Council of Ministers. Therefore, the Constitution, when it wanted the governor to act in his discretion, it carried, my lord, an express provision. In fact, my lord, even in the 6th schedule, your lordships will notice various paragraphs of the 6th schedule contain provisions which indicate that he will act in consultation with the Council of Ministers. There are some provisions which say that he will act in his individual discretion. Therefore, my lord, it is important to note that when discretion is exercised by the governor by virtue of being a chancellor under a state enactment, or when he decides to give sanction to prosecute, well, that sanction to prosecute is not under the Constitution. That sanction to prosecute is under the Prevention of Corruption Act, because he is the authority who is competent to remove the chief minister or a minister. That is why, my lord, he exercises that power. He exercises the power by virtue of a statute. But here, my lord, we are talking about discretion under 163. My lord, this is the point which I wish to develop for your lordship's consideration. No, I'll continue, my lord. Would your lordships like to pause here? I just wanted to know. Your lordships.
Want that to be.
No, my lord, I can start, my lord. I'll start on the same point, but I'll then have a, I'll
Start that point afresh.
Yes, yes, I would like to start that. I just wanted to give a summary, my lord, an overview, a synoptic view.
Have you apportioned the time?
Certainly, my lord, you all will.
We'll give you 1.5 hour more on 10th also. From the rejoin the time.
Grateful.